We are on the record. This is a continuation of the Public Service Commission's administrative meeting for March 22nd, 2023. At this point, we will call to the docket case number 9690 in the matter of the complaint of the Public Service Commission staff against SFE Energy Maryland Incorporated, doing business as SFE or SFE Energy. On January 30th, 2023, we issued order number 90488. We've since issued a number of subsequent orders extending today's show cause hearing. And we now have the parties before us. So let's begin by taking appearances, starting with staff counsel.
Good morning. My name is Hunter Davis. I'm appearing on behalf of staff counsel.
Any other appearances, Mr. Davis?
Okay. We also have Peter Wilson on behalf of staff counsel.
Thank you. Office of People's Counsel.
Good morning, Mr. Chairman and Commissioners. Jacob Auslander on behalf of the Maryland Office of People's Counsel, and here with me today is Ryan Shue, who's also an Assistant People's Counsel.
Thank you. Good morning to you both. Counsel for the retail supplier.
Good morning, Mr. Chairman, Commissioners. My name is Brian Green for the law firm Green Herlocker. I'll be appearing on behalf of SFE Energy Maryland Incorporated.
Thank you. Do the parties wish to present a settlement, or are you prepared to litigate today? Mr. Green.
We would love to present a settlement. However, we do not have one today. We are prepared to litigate.
Okay. And the other parties as well, Mr. Auslander?
Yes, so there was no opportunity to, or as far as I know, there was no conversation about a settlement. So.
Okay. Mr. Davis?
Yes, we're prepared to litigate. We're prepared to litigate today. We have no settlement at this moment.
Thank you. So we could plan the rest of the morning or afternoon. How many witnesses do you have?
Staff has one witness.
Okay. Mr. Auslander?
We have no witnesses, Your Honor.
Mr. Green?
The company has one witness, and if I may, with respect to settlement, there were some introductory discussions between the company and staff. I just got in this case 2 weeks ago, so I apologize, but to the extent that the commission were to deem it appropriate to allow for some time for discussion among the OPC staff and the company would very much welcome that. I just wanted to make sure that that was transparent and out there so that you understood.
Thank you, Mr. Green. Although that time has passed, that time would have been before today. I recognize that you only joined the litigation legal team for SFE March 15th, thereabouts?
Thereabouts, yes, sir.
Okay. Is your co-counsel here today?
No. Mr. Puckner is not available.
Okay. There were a number of attorneys with Phillips Lytle. None of them are here?
No, they are not.
Okay. Okay. Well, obviously the commission always encourages the parties to settle before a hearing date, but we will move forward. My local rules of practice and procedure, which are on the PSC website, are in effect. We also have some non-public information before us today, filed by both Office of People's Counsel and by SFE. We are on the record. This is streaming on YouTube. I would like to keep this public to the extent we can. Of course, if we venture into non-public discussion or questioning, the attorneys should make note of that, and I will make a determination if we need to go into a closed session. Since we have two entities that have the name SFE involved, I would ask that we just refer to SFE when we're referring to SFE Maryland. To the extent that we're referring to SFE Energy, I would prefer that the parties just refer to that as the parent. Any questions? Seeing none. I suspect we have a number of motions that we need to address, but before we do so, any preliminary matters? Seeing none.
Your Honor, one point that I'd like to make just at the outset is that a lot of the material that was provided in this case from SFE and SFE's filing is marked confidential, so I am worried about discussing any of it. And maybe SFE could speak to what is or what still needs to remain designated as confidential so that we don't get slipped up.
You make a very fine point, Mr. Auslander, because SFE painted almost all of its exhibits as trade secret when they're handing out business cards to customers, and yet they're saying that's trade secret. They refer to the statewide settlement agreement, which is in the public domain, as trade secret. So I am very concerned that SFE's attorneys have taken liberties here that marking everything as non-public. Mr. Green.
I can speak to that. There is significant information there is significant information that is marked in the response, the exhibits that you mentioned as confidential. Much of that will not be confidential today. I guess we can kind of go as we take it as we go, is my suggestion, but we have a significant exhibits and information with respect to customer counts and so on and so forth that has been marked confidential in the past in this case, which we're prepared to make public. So we hope that we don't have any problems with this along the way.
As you stated, we'll take it as we go. To the extent there are objections, I'll rule on those objections as we move forward. Okay, motions. Any motions? Mr. Davis. Motion to amend your complaint?
Yes, staff filed a amendment by interlineation on
February 27th.
yes, February 27th, and so staff would move to amend the complaint to include the contents of the amendment by interlineation.
And Mr. Davis, that was simply correcting some errors with respect to the Comar sites, is that right?
Correct. Errors with the Comar site and correcting the separating essentially these certain complaints that were identified as residential or non-residential and assigning them with the other complaints that were identified as residential.
Thank you. Any objection?
Your Honor, we filed a response to that, but I have nothing further to add.
Thank you.
No objection from OPC.
Thank you. Staff's motion is granted. The complaint is modified, as staff noted in its February 27th pleading. Any additional motions? Seeing none, we'll begin with opening statements. Parties may wish to reserve their opening statement or decline to provide one entirely. Mr. Davis.
So staff's complaint generally relates to the quantity of CAD complaints that were filed against SFE Maryland in the review period of January 1, 2020 to September 30th, 2022. So staff believes that the quantity of complaints and the nature of these complaints demonstrate issues with compliance and regulatory compliance with SFE and a disregard for customer protections. And thus, staff believes that SFE should be required to show cause for why its operation should not be impacted by this substantial number of complaints and lack of customer protections.
Thank you. Mr. Auslander.
Thank you, Your Honor. OPC generally supports the observations that staff made in its complaint and in its testimony filed last week. We mentioned in our comments that StateWise's that SFE's answer claims that it had implemented a number of elements of the settlement reached in a case involving one of its affiliates StateWise. But as we pointed out in our comments, that there were some modifications to that settlement made by the public utility law judge in that case that we do not believe were implemented by SFE. So we do have some issues with the way SFE has represented its modifications to the commission. We did not have a lot of time to prepare and take the discovery in this case, but we do have serious concerns about the company's monitoring and compliance of its sales agents. We've requested from the company on multiple occasions documentation about the peddler's licenses for their door-to-door sales agents, and as of today's hearing, we still do not have documentation from the company on that point. That is one violation that we were able to identify. And then finally, one of the types of relief that OPC is most interested in these cases is customer refunds. And so we would like to further explore that, that type of relief. I know that staff's recommendations as far as sanctions and penalties in this case do not explicitly include additional refunds, but we would ask, for the commission to consider a mechanism by which customers could be identified and could receive refunds as part of any relief granted in this case.
Thank you. Mr. Green.
Mr. Chairman, Commissioners, on Monday afternoon, the company filed reply comments. They were intended to be brief and to the point and only to hit the high issues. I hope that you find that we succeeded in, at least in that goal, if not the merits. I would like to adopt those as my opening statement today and just make the following points. First of all, this is not a case where the parent company shifted business operations from Statewise over to another member of the corporate family, SFE. The evidence today will show that SFE did not increase the number of its vendors. It did not tell its one vendor for door-to-door to ramp up operations anywhere in Maryland. It continued business as usual. What it did do was modify certain of its documents to conform with what it thought it was legally obligated to do as a result of the statewide settlement and proposed order that the Commission adopted in January of 2022 as a final order. And we'll talk about that today, as well as the changes that the company continued to make to refine its contracts in consultation with CAD and as a result of certain CAD decisions. In that regard, we appreciate staff's comments in its testimony that the company's recognizing the company's good faith efforts to comply. We do disagree with staff's testimony where Mr. Herbert will testify that there's a suggestion of a pattern of deceptive practices or unauthorized enrollments. We believe that the evidence today will actually show just the opposite, that the CAD decisions entered in 2020 and 2021, the actual decisions show that there is no pattern of deception, and the reason for that is that SFE engages in a pretty intense enrollment process. You have to really want to be an SFE customer. You have to go through the contract. You have to complete an eTPV or a TPV, whichever one you choose, whether it's on the tablet or by phone. You have to complete a successful quality assurance phone call from a live person at SFE. And then once your enrollment is submitted and the EDI transaction comes back from the utility, the company now, as a result of Statewise, will check the name of the account holder to ensure that it matches the name that the customer gave them at the enrollment. So you have to go 4 for 4. The only requirement in a door-to-door enrollment is a signed contract. And yet they have a TPV, they have a quality assurance phone call, and then they have the back-end account holder check. So they go way above and beyond the minimum requirements of an enrollment, recognizing that door-to-door is a noisy channel. I think everyone in the room can agree to that. I mean, the biggest complaint getters on the Commission's report every quarter are the door-to-door companies, right? So the company has implemented what is a very rigorous enrollment process in order to offset that, and CAD has recognized that on at least 26 occasions in 2020 and 2021, and the evidence will show that today. So with those improvements and with that background, the company would ask that this case be dismissed, or alternatively, as we said in our comments filed Monday, that it be delegated to a public utility law judge and the issues being narrowly defined. And with that, I'll conclude my opening statement. Thank you.
Thank you, Mr. Green. Are you making a motion to dismiss at this time?
I would like to do that, yes, but I am happy to do it after the evidence comes in, but I will do it now as well.
Okay, well, the motion is denied at this point. I believe, based on the evidence provided so far, staff has made a prima facie case that violations of statute and regulations have occurred. Staff, you may call your first witness.
Staff calls witness Charles Herbert.
Mr. Herbert, if you could do not enter the well, if you could head to your right. Thank you. Yes, please. Mr. Herbert, if you could please enter the box. Don't hit your head on the TV. Mr. Herbert, actually, can you do me a favor and just move the TV? Push it. Yeah, push it towards the wall. Yeah, there we go, so we don't have any injuries today. Thank you. Mr. Herbert, if you could please raise your right hand.
Do solemnly affirm that the testimony you state today in this matter today are the truth, the whole truth, and nothing but the truth.
I do.
State your full name.
Charles Herbert,
Spell your last name.
Herbert.
Give me your business address, please.
6 St. Paul Street, Baltimore, Maryland, 21202.
Thank you very much. Peter?
Thank you.
Mr. Herbert, I'm not sure if the green light is on your microphone, but if not, if you could turn that on.
It is.
Thank you.
All right. Are you ready?
Yes.
By whom are you employed, Mr. Herbert?
I'm employed by the Maryland Public Service Commission,
And what is your position with the commission?
regulatory economist in the Energy Analysis and Planning Division.
And do you have with you a document entitled Direct Testimony of Charles Herbert, consisting of 16 pages of text and 2 exhibits?
Yes,
Has this document been pre-filed in this case?
it has.
Was this document prepared by you or prepared under your supervision?
I prepared it.
Do you have any additions, deletions, or changes that you would like to make to this document at this time?
Not at this time.
Do you adopt this document as your direct testimony in this case?
Yes.
Your Honor, I ask that the direct testimony of Charles Herbert, consisting of 16 pages and 2 exhibits, be marked for identification as Staff Exhibit 1.
Seeing no objection, this document is marked as Staff Exhibit Number 1.
At this time, I would like to move Staff Exhibit 1 into evidence subject to cross-examination.
So moved.
The witness is available for cross.
Thank you. Mr. Auslander, any cross?
Some brief cross, Your Honor. Good morning, Mr. Herbert. How are you?
I'm doing well. How are you?
Great. So I just wanted to talk a little bit about the complaints that you reviewed as you prepared your testimony. How many CAD complaints did you review as you prepared this?
Get to it. We looked at 136 complaints. So that was all the complaints between January 1st, 2020 and September 30th of 2022.
Okay, so nothing before and nothing after that period.
Yeah, that's correct.
Okay, and then of those complaints, your testimony identifies a number of violations that you believe were evidenced by the CAD files that you reviewed.
Yes.
And can you briefly describe those violations?
Sure. So, the majority of the violations had to do with deficiencies in contracting requirements. In some cases, there was no wet signature provided on the contract. In other cases, in one case there was a violation, CAD found violation of the Maryland Telephone Solicitations Act. And also, there were a number of violations where customer did not provide consent that CAD determined. Beyond that, there were CAD found in favor of the customer several cases of misrepresentation during the door-to-door sales process.
And by misrepresentation, you mean that the sales agents told the customers things that were untrue?
That's correct.
Okay, and then of the CAD complaints, I think you might have touched on it, but I just want to be clear. Were there any instances of unauthorized enrollments or slamming?
Yes, there were a number of violations where CAD ruled that the customer had not provided the necessary consent for an enrollment as required by COMAR.
Okay, and I think that on page 9, if you could turn to page 9 of your testimony, line 3, you talk about that there's no surveillance system used by SFE to monitor exactly what transpires during a given door-to-door sale.
That's correct.
Okay, and so that is why you were forced to rely on the CAD complaints themselves as your source for making your conclusions.
Yes, that is correct.
Okay, and then the company has claimed that they've made a number of reforms to their contracting practices, but you looked at that at those efforts, and you were not convinced that those reforms were meaningful or long-lasting.
I object. It's not my witness, but I object to the extent that that's not his testimony.
Okay, can you turn to
Or
page?
may not be.
Okay, a few rules have already been broken. Mr. Green, you cannot object.
Okay, got it.
Mr. Auslander, you're violating. This is where Mr. Green could have objected but didn't. With respect to my rule number 4, it sounds like you're on the same side of the issue with staff, and you're asking questions of the witness that are, I think, clearly in his testimony.
Yes, that is correct, Your Honor. I am building up to the main point of disagreement that OPC has with Mr. Herbert's testimony, which is the penalties and sanctions.
All right, thank you for the preview. I'll allow you a little more foundation. We'll get there quickly. I don't believe Mr. Davis mentioned penalties in his opening statement. Did you?
I did not mention
Okay.
penalties.
Mr. Auslander.
Okay, and I'll just go ahead and jump right to that point so I don't violate any more of the unwritten rules.
Oh, well, it's number 4. Right?
So, Mr. Herbert, you have recommended a civil penalty and a license revocation in this case.
Yes, that's correct.
And what was the amount of the civil penalty that you recommended?
Civil penalty is the amount of $400,000.
Okay, and I think that you mentioned that you arrived at that penalty after considering the factors in Public Utilities Article Section 7-507L3.
Yes.
Did, as part of your development of that civil penalty, did you take a look at the company's revenues or their earnings and attempt to set a penalty that would likely deter the company from engaging in this activity in the future?
We did not view revenues as a factor in this.
Okay, and then just so I'm clear, your recommendations do not include any further customer refunds as part of the relief in this case?
They do not.
Okay, and is there any reason for that?
Well, the main reasoning is that since we, especially in the case of misrepresentations, there are a number of allegations of misrepresentation, And as demonstrated in the testimony, because there's no surveillance system used by SFE, we have to rely on both on the complaint, the details surrounding the complaint, as well as the judgment that CAD exercises. And so, because there's no surefire way to prove whether misrepresentation, for instance, occurred, refunds were not something that we looked into, because in order to issue refunds, we felt like it had to be absolutely sure that a customer was entitled to that money, because the violation did in fact occur.
Okay, and then just so I'm clear, and in order to be sure, you would essentially need to have some contact with the customers, because that's the only way you can really know what happened in any given transaction.
Yeah.
Okay, thank you. No more questions, Your Honor.
Mr. Green.
Okay. Good morning, Mr. Herbert.
Morning.
Is this your first time as a witness?
It is.
All right, welcome.
Thank you.
I hope this isn't too painful for you. Can you turn to page 2 of your testimony, please? So sorry, let me know when you're there.
Mr. Green, would you specify the first few words of the question? I have some pages marked in Roman numerals, so.
Okay, it's what is the purpose of your testimony?
Okay. I'm there. Thank you.
And you see the numbers 1, 2, and 3 on
Ye-
lines 5 through 8?
Yes.
Okay. Can you, you have, as I understand your testimony, staff has 3 main buckets of concerns. Number 1 here on line 5 is the misrepresentations. Is that I'm paraphrasing, but you refer to it as false and misleading information, right?
That's correct.
Okay. The second is the unauthorized enrollment without consent.
Yes.
Right. And we'll talk about this in a couple minutes, but would you agree with me that the large, I guess, number of complaints in that bucket are non-account holders enrolling? And let me paint the picture a little better. CAD goes through the complaint and finds that the person who authorized and signed up for the enrollment is not the same name on the utility account.
Oh, yeah. Non-customers of record. Yes.
Okay. All right. And then the third bucket would be the providing inadequate information to the customer. That's the issue with the contracts that you discuss later on in your testimony?
Yes.
Okay. All right. So, and then further down on page 2, same page, you start to get into why you think that there's a pattern that suggests non-compliance.
Yes.
And you arrived at this, you're able to make this determination because you're familiar with the complaint process, right?
Yes.
And you reviewed the complaints.
Yes.
And then on line 18 to 19, you say, I am additionally familiar with the complaint data of this case and how it is statistically distributed. Do you see
Yes.
that there on line 19?
Yes.
Okay. Does that mean that you took the statistically distributed, that confused me, and I'm wondering if you can explain what that means. Does that mean that you looked at the number of complaints versus what? Or the number of infractions versus something? Like, what are the statistics?
So when I use the word distributed here, I'm actually talking about the nature or natures of the complaints as they would be placed into different buckets or categories.
I see.
So unauthorized enrollment would be one category, and then the misrepresentations would be another, and then finally, like contract deficiencies would be another.
Okay, so you took the we'll start with misrepresentations because that's actually next on my list. So, you took the misrepresentation allegations, you put them in a bucket, and the number was I think your number was 46.
Yes.
Right. Okay, and then where does the statistical analysis come in from there?
So after breaking the complaints into various categories, at that point, the process was to go in and examine the complaints within each localized category. So first of all, which complaints did CAD rule in favor of versus not? And in the case of misrepresentations, there would be more subcategories. As shown in the chart in my testimony, several complainants allege similar instances. Door-to-door sales representative saying, you know, I'm with the BGE or I'm with the Maryland Public Service Commission to fix a problem. So most of the analysis here was really division among categories and then taking counts and percentages of complaints that fall into such categories, and then looking deeper to see are there similarities ranging across the complaints that we have access to.
Okay, so your top number then was 46 for misrepresentations. You looked at how many, and let me, before I ask that question, on line 3 on page 4, it starts, the page starts with yes. I discovered. Do you see that?
Yes.
Okay. On line 3, you say 15 complaints were verified as being in favor of the customer. Does that just mean that the CAD decided in favor of the customer?
Yeah, that's what that means.
Okay. All right. I just wanted to make sure we were not talking about something else. So you took the 15 complaints and compared it to the 46 total complaints filed. That's the statistical analysis that you did?
So I looked across, I reviewed all the misrepresentation allegations, but when I got to the 15 that were CAD ruled in favor of the customer, I looked particularly closely at the situations surrounding those allegations.
Okay. Is there any industry standard that you're aware of for compliance purposes that staff would have used?
I'm not aware of any industry standard proportion at this time, no.
So you didn't do like a complaint to total customer ratio?
No, we didn't use that type of ratio or proportion.
And you didn't look at complaint to total number of enrollments as opposed to total number of current customers at a given time? You didn't do that either, right?
No. Part of the reason for that is that would require also going more into considering the circumstances behind the enrollments, obviously, to examine all of the complaints, for instance, of door-to-door issues versus all enrollments. I would consider that to be incorrect to do that type of analysis because not every customer is enrolled exactly the same way. So obviously, we would need to make sure we're comparing apples to apples instead of causing any incorrect conclusions based on the groups and how we're proportionalizing.
You said not every customer is enrolled the same way, but these are all door-to-door customers, right?
The misrepresentations, yes.
Okay, but you would agree with me that 15 decisions when there are 2,500 total customers would be viewed a little differently in terms of a pattern in practice as opposed to if there were 25,000 customers. Statistically, in determining a pattern, wouldn't that be a difference?
So I consider, I agree that size may be one factor, obviously magnitude that one to consider when alleging a pattern. However, that is not the only indicator of a pattern. If you know, in this case, I saw multiple customers using very similar details across several of the allegations. For instance, in the table where I outline the misrepresentations, a few of the complainants allege that the reason that the agent was at the doorstep or said they were at the doorstep was because they needed to fix an issue. And the evidence they gave for that was that their codes R and D had a problem. And when I see that, I would be hard pressed to think that multiple customers could come up with something that specific.
Okay, but did you even ask what is the total customer count for SFE? Because it's nowhere in your testimony or your analysis. You didn't take that into consideration at all?
Yeah, we did not use the total customer count for the company.
And you didn't think that the total number of door-to-door enrollments over the course of the time period involved was a factor in determining whether there was a pattern?
No, we reviewed believe that the similarity of the allegations made by the customers was enough to suggest there would be an appearance of at least a localized pattern of behaviors by door-to-door agents that suggest that they're not being forthcoming with the customers.
What do you mean by a localized pattern?
Not all of the complaints specify exactly the same type of misrepresentation. As noted in my testimony, some misrepresentations were actually, they were not misrepresenting the affiliation, but the ability to obtain savings, guaranteed savings, by switching to SFE. So within certain scopes, in this case a scope being the allegations of deceiving the customer as to the affiliation of the agent, it appeared that there was a sort of reoccurrence and a continuous reoccurrence because these allegations are spread out across a period of time, that this is not something that I could say was isolated. It looked more like something that was reminiscent of a pattern.
Okay, but that's not based, I mean, you would agree that what you just said is not based on any statistical analysis. It's you looking at a small number of decisions that went against the company and extrapolating that out to a pattern that could affect thousands and thousands, if not tens of thousands, of enrollees.
Yes.
Okay. Let's turn to a slightly different issue. Are you familiar with the requirements in the COMARS and Door-to-Door Sales Act for what is needed to enroll a customer in a door-to-door setting?
I don't know the entire thing.
Okay,
off the top
let's
of
do
my
it this way. Would you agree with me that in the door-to-door setting, the customer must sign a contract?
Yes.
Okay. And would you also agree with me that the contract must include certain notices regarding the right to rescission, and there's other minimum requirements that are necessary?
Yes.
Okay. And would you agree with me that once the contract is signed, there's no further action legally required by the supplier to enroll the customer, right? There's no TPV required, third-party verification. There's no phone call that's required in the rules or the law. You would agree with me on that, right?
I would like to object to this question. It sounds like a legal conclusion that you're asking for.
I'm asking for if he's aware. So
Okay.
that was the premise of the question. Maybe I'll rephrase it. Are you aware of whether, once the contract is signed, are you aware of any other requirement from the supplier's perspective to enroll the customer?
I'm not aware of any other requirements.
Are you aware, when you did your testimony, that SFE does these things? They do a TPV and they do a quality assurance phone call to the customer?
Yes.
Okay. Did you, in your analysis, look at the CAD complaints on misrepresentations that were decided in the company's favor?
Yes.
And would it surprise you if I told you that we found 26 decisions in 2020 and 2021 where CAD found no misrepresentations and validated the enrollment?
It would not.
And yet you don't mention that in your testimony?
No.
Okay. Your Honor, may I approach?
You may. Yeah, we're getting copies right now.
I believe in your testimony, we all ready? I believe in your testimony, Mr. Herbert, you've stated that you reviewed all the CAD complaints.
Yes.
Do you recognize these as complaints in 2020 and 2021 in which CAD determined that the company did not engage in misrepresentations based on, in part, on the contracts that were signed and the ETPVs that were completed?
Yes.
Okay. Your Honor, I'd ask that this package of CAD complaints be marked for identification as SFE Exhibit 1.
Seeing no objections, so marked as SFE Exhibit Number 1.
And I'll go ahead, since he's recognized it, go ahead and move for its admission as SFE Exhibit 1.
Mr. Chairman.
Commissioner Linton.
Thank you, Mr. Chairman. I guess I would just note, and there's no concern about it being admitted, but or the motion for it to be admitted, but there is some customer-sensitive information here, so it may be needed to be moved in.
This should be a confidential exhibit. Thank you, Commissioner. It has personal identifiable information, and I believe the Commission's practice is that if there is, in the CAD-related documents, if there's identifiable information, we mark that as confidential.
We'll remark this as SFE Exhibit 1C, as in confidential. Any objection to moving this
Yes.
document?
I'm objecting to the relevance of this. I'm not certain what the relevance of these complaints is to this discussion or to this hearing.
Well, Mr. Green, you're stating, and I have not reviewed all of these letters, you're stating that these are all findings of CAD in favor of your client?
They are, and they're actually already in evidence. They were attached to Mr. Herbert's testimony. I've just selected those as a more convenient way to look at them.
Mr. Davis?
All right.
Okay, they are moved into evidence.
So 26 out of the 46, Mr. Herbert, were misrepresentation claims that were ruled in favor of the customer. Is that accurate?
Yes.
So would you agree with me that based on your statistical analysis, which considered the number of CAD decisions in one favor, right, in one direction, versus the 46, that I could look at these 26 and conclude that there's no pattern of misrepresentations?
I'm object. That's object to this question. It's a you're providing a conclusion to the witness.
Well, I didn't hear a question asked. Did you ask a question, Mr. Green?
Yes, I did. I said, would you agree with me that I could look at these 26 decisions and, based on his analysis, conclude that there's no pattern of misrepresentations?
This the question is requesting additional analysis of these cases that's outside of the scope of his testimony.
He's asking to conclude what.
I'm going to overrule the question. You may answer, Mr. Green.
Overrule the objection or the question?
The objection,
Okay,
not the
all right.
question. You may answer the question.
Okay, so
Do you need the question again?
yes.
Okay, Mr. Green.
Okay. Your prior testimony was that you looked at the 15 CAD decisions in favor of the customer in relation to the 46 total and concluded that there, I believe your language is, there appears to be a pattern of deceptive marketing practices. So my question is, would you agree with me that someone could look at those 26 decisions out of the 46 in favor of SFE and conclude that no pattern exists?
Speculate as to what someone can conclude.
I would not say so because, as I stated, there is no surefire way to determine whether an allegation was true or false. The best we have to go off of is the details, specificity of the complaint, and the judgment exercised by CAD. It may very well be that there are true allegations even within the complaints that were found in favor of SFE. But in several of those decisions, CAD noted that there was not a support of misrepresentation. And, SFE does not record its door-to-door sales. So we're in absence of that surveillance. I cannot conclude that among those complaints any are true, but I also cannot conclude that all of them are false.
So you've now mentioned recording conversations at the door a few times in response to Mr. Auslander and now, and it's in your testimony. Is that required, do you know, by a supplier to record a conversation at the door?
Not to my knowledge.
And are you aware of any supplier in Maryland that does that?
I am not aware.
Okay. But you would agree that a decision from CAD is staff's opinion that it is a conclusion of law and a finding on the facts of the case?
I would object. That sounds like you're asking for a legal conclusion.
Sustained.
Would you agree that CAD's decisions or the conclusions of CAD's investigations are binding on all parties?
I would object again. Binding has a legal significance.
Sustained.
Very well. For the record, I read that out of staff's comments filed last Thursday. So, so let's move on to the unauthorized enrollments. I believe that is on page 9. It's,
Yeah, I'm there.
okay, and I think you've already agreed with me that, I'm sorry, on the top of page 10, line 1, CAD found 42 invalid enrollments, and I believe you've, do you see that?
Yes.
And I don't know the number, but the majority of those were non-account holder enrollments. Is that accurate?
Yes.
Okay. And are you aware whether SFE asks the customer throughout the enrollment process if they are the account holder?
I'm not aware if that's confirmed.
So you don't know if it's in the contract or the TPV or the quality assurance call. You're not aware of that?
I think in the TPV.
I would just remind the witness, Mr. Herbert, don't guess if you don't know the answer.
I'm not sure.
Okay, fair enough. Are you aware that SFE implemented an EDI check process in January 2022? And I can explain that if you need me to, but I'm hoping you understand what I'm talking about.
If you
Let me rephrase. Fair, that's okay. If you don't understand something I'm asking, just please tell me. I'm not the most gifted in fashioning questions. So, are you aware that SFE modified its enrollment process in January 2022 to implement a check to ensure that the name on the customer account was the same name on the utility account?
Yes.
And do you know whether that process is working or not? Are you aware of any? Have you heard any statistics or any discussions with the company about that?
I would object to this. This is outside of the review period, and he mentioned earlier that his testimony stuck to January 20 to September 30th, 22.
Sustained.
On the top of page 10, in line 4 to 5, you mentioned 2 commercial enrollments where the company didn't obtain consent. Do you see that?
Yes.
So this is an interesting issue to me, because if there's a business, do you know the name of the?
I'm objecting to this line of questioning. This is not a question.
I don't think Mr. Green got to his
I
question.
haven't.
He's testifying.
Mr. Green, what's your
Okay,
question?
I will withdraw the phrase. This is an interesting issue to me.
Well, you've piqued my curiosity now.
Do you know? Sorry. Do you know if there's a non-residential account? How is that listed on the utility bill? Who is the account holder?
The company designates, based on my review of the complaints involving commercial customers, there's an individual who's designated by the company to make that decision.
But the utility bill would just have the name of the entity on it, correct, as the account holder?
Yes.
Okay. So if a supplier such as SFE or a broker, in this case, were to call a company and ask, are you authorized to make decisions on behalf of the company, and the answer is yes, what more should a supplier do to ensure that that person has authority?
Object to this question. It's speculative.
Your Honor, I don't think it's speculative at all.
You're asking a question of what he would, of what
Uh,
a company should do in a certain situation.
Your Honor, there's he's saying that we have failed to obtain consent in a commercial setting.
And you're asking how would you otherwise obtain
How would you do
consent? I'm going to allow the witness to respond.
So the question, Mr. Green, is how would I consider or double verify that the account holder matches what's on the bill? Is that what you're asking?
How would you ensure that you're enrolling someone that has the authority when they've told you they have the authority?
I would probably refer the matter to other decision makers for the business, because in several of these complaints, the complainant is someone who is high on the corporate food chain for the company, and their partner or someone else in the business made the decision, but they were still not the authorized person who handles the accounts. So, in terms of verifying the account holder, I would just make all decision makers in the business aware so that the account holder is aware.
So you would, if the supplier approaches a business, person says, I'm a manager, I have authority to change the account, and it's done. The EDI transaction, would you agree, is going to come back and it's only going to have the entity name. It's not going to say who's authorized, correct?
Mr.
not sure.
Herbert explained that he would, in response to your question, Mr. Green, that he would involve more people, higher ups, lots of people to triple check or quadruple check.
Okay, fair enough. Let's talk about the contracting issues. So you said on page 2 that there was a possible pattern of, I believe you said, providing inadequate information. I believe it was number 3.
Yes.
Yeah. Let me go ahead and pass this out. Make sure I count right this time. There's 3.
Thanks, Jim.
Is it okay, Your Honor?
One of these. Sorry.
Give it right back. So, Mr. Herbert, do you recognize the document that I have handed to you just now?
I do.
And can you tell the commission what it is, please?
This is the contract summary document, and the agreement details that is provided for an enrollment.
And I will represent to you that I copied this from the complaint number that you cite, 035938, just so, I don't expect you to agree with that, but just so we're all on the same page of where this particular document came from.
What was that number again?
035,938. It is cited in one of the footnotes in Mr. Herbert's testimony. Do you recognize the first 2 pages as a gas contract summary and an electric contract summary?
Yes.
And do you see any information that's missing from the electric or contract summaries in your review of either this document or similar documents?
I would object. Mr. Herbert's not a lawyer.
Sustained, and I don't think Mr. Herbert could review all this on the stand and see what's not there.
Would you agree with me that the pages are numbered at the bottom left?
Sorry, Mr. Green, could you repeat that, please?
Would you agree with me that the pages, beginning with page 1, which is the welcome letter here, and it has the customer's name on the top left, that there are pages,
Not all the pages have numbers.
correct, right. The page 2 is the natural gas agreement details. And then we go through to page 13 to the end. Is that an accurate description of the page numbers?
Yeah, I see numbered from page 2 to the end.
Correct, okay. And if you turn to page 10, or what is marked as page 10, would you agree with me that, would you agree with me that there's what appears to be a signature from the customer there?
This appears to be a signature.
Okay. Do you have any reason to believe in your review of the CAD documents that SFE's contract changed materially from 2020 to 2021 to 2022?
I do not.
So, are you aware in the CAD complaints whether any customer complained about receiving inadequate information or said that this presentation of documents confused them?
Broadly speaking, I did not see instances of complaining directly about the enrollment materials.
Okay. And so my question to you is, what is inadequate about this information that's provided to the customer?
I would object. This is, you're asking about the review of a contract and adequacy in terms of legal enforcement.
Your Honor, he's testified that SFE is, on page 2, suggests a pattern of providing inadequate information. And I'm asking him what's inadequate about it.
So, the objection is more aimed towards your question about the adequacy of this contract that we're looking at currently. If you're asking a general question, I would not have an objection.
Mr. Green, are we looking at Mr. Herbert's testimony starting on page 10? Is that?
Well, the statement that I was referring to just now is on page 2, line 8, where he says the purpose of his testimony is he says it suggests a pattern of, number 3 there on line 8, providing inadequate information to allow a customer to make an informed choice regarding the purchase of electricity and natural gas services. And I'm asking him, what is inadequate about this pack of documents, these documents that I've given him?
Yeah, so the objection is that you're asking for a conclusion based on a contract that he's looking at currently and not the entirety of the testimony, which takes into account all of the complaints that were filed against SFE.
He can ask for the basis of his opinion, but he's assuming this is the basis of it.
I'm floored that this is an objectionable question. I mean, this goes to the heart of, he's suggesting a pattern based on providing inadequate information. I'm showing him the information that he's agreed has not materially altered since 2020, and I'm asking him what's inadequate about it.
Mr. Green, you stated on page 2, item number 3 is respect to contracting. So I'm moving, and that's just the summary. So we move forward in his testimony, page 10. Is that where we are? Effectively contracting?
That contracting section, yes, sir.
Okay. One moment.
I would also add that to the extent that Mr. Herbert's testimony clearly lays out his position, the question may be redundant at this point.
Well, that's my concern. That's what I'm looking at here. The question is, does SFE appear to be compliant with contracting requirements? And Mr. Herbert responds, no. I found that 26 of the 46 complaints in the staff complaint were determined by CAD to be violations of specified COMAR regulations.
But, Your Honor, if you look at line 10, 12 instances were 12 were instances of contracts with insufficient material terms and conditions.
Okay.
And he has footnote 10, and the first complaint number is 000-35938. That is the contract I'm showing him. I would like to know what is inadequate or what are the insufficient material terms and conditions that are in that.
So I would object again that the testimony as a whole is based on CAD's findings and not on Mr. Herbert's independent analysis of each contract that was contained in the complaint.
Now, Mr. Herbert does cite to this complaint specifically. He did state that there were instances of contracts with insufficient material terms and conditions.
I would agree with that. However, the complaint as a whole in staff's evaluation includes CAD's findings, and it includes the entirety of the contract that was provided by SFE.
Oh, the witness could state that if that's his position, that there's items outside of what we have in front of us that have influenced his decision to state and testify that there are terms and conditions that were insufficient. So Mr. Green's question may be answered. Do you need it asked again? Mr. Herbert, do you need it asked again?
Yes, please.
Your Honor, can I have this document marked as SFE Exhibit 2? And
Confidential?
It is confidential, yes, sir.
All right, so marked as SFE Exhibit 2C.
So let's ask it a different way. I'm on page 10, line 10. It starts with the number 26, comma. Do you see that?
Yes.
Okay. And then you say 12 were instances of contracts with insufficient material terms and conditions.
Yes.
Now, I direct your attention to the document marked as SFE 2C. And my question is, what are the insufficient material terms and conditions in that document?
Oh. Well, Mr. Green, this document includes the contract summary and various other components. However, in its review of contracting requirements, CAD makes a distinction between contract summary and a contract. And so if not all of the material terms and conditions are in the contract, even if they're in the contract summary, then CAD would not rule that it's valid enrollment.
Can I direct your attention to what has been marked, what is page 4? It's identified in the bottom left as page 4 of the document. Right, and you see on the top there where it says terms and conditions.
Yes.
But you're not aware of any term or condition that is missing from this document, are you?
I would object. You're
reliance.
asking for a review of a legal document.
You're solely relying on what CAD said, right?
Mr. Green, once an objection is put on the record,
Understood.
everybody needs to be quiet. The objection is overruled. The witness has stated that he's noted instances of the insufficient material terms and conditions with a number of contracts, including the contract or whatever document this is. Mr. Green, what is this document? What is the document that we have in front of us?
This is the contract summaries for the natural gas and electric product that were offered to this particular customer, along with the welcome letter and the contract, and that is signed. 2 copies of the notice of cancellation that is provided at the door, along with the business card the customer receives from a copy of and the name of the agent. And
So your question to the witness is there anything insufficient or lacking with respect to what he has in his hands as marked as SFE Exhibit 2C?
correct.
All right, Mr. Herbert, do you have a response?
I couldn't say whether any terms and conditions are missing from the contract summary. However, CAD also requires that all terms and conditions be outlined in a contract document.
So, but you haven't reviewed this contract or any contract to determine whether all material terms are in the contract, have you?
CAD determined whether all material terms and conditions were present in contract.
So you're relying 100% on CAD on this issue, correct?
With respect to legal requirements for terms and conditions, yes.
And the witness has stated in his testimony that I found that these specified complaints were determined by CAD, not by Mr. Herbert himself.
I understand. Your Honor, I'd ask that the document marked as SFE 2C be entered into the record as SFE 2C.
So moved.
Mr. Herbert, can I direct your attention to page 11, line 5?
Yes.
You testify that SFE has also seemingly failed to include key components of the contract that would be necessary for full valid consent of the customer. Do you see that?
Yes.
Okay. And am I understanding this correctly, that the rationale or the premise of that statement is that you found a contract that didn't have a cancellation notice in the immediate proximity of the signature line as required by the Door-to-Door Sales Act?
Yeah, it's stated in the testimony. CAD found a violation of the common law code where a statement which is in the immediate proximity of the space was missing.
Okay. Do you know whether whether SFE includes the notice of 3-day rescission in the contract summary that it gives to customers? Let's do it this way. Can you go to SFE 2C, please?
Yeah.
And the first page, natural gas contract summary, do you see that?
Yes.
In the left, there's a, excuse me, there's a row that says right to cancel / rescind. Do you see that?
Yes.
And so would you agree with me that in the explanation to the right, it informs the customer about the 3 business day right to rescind?
Yes.
Okay, and the next page, please. The electric contract summary. Same thing, same row, right to cancel, rescind, and then the 3-day right to rescission.
Yes.
And then can you please turn to what is marked as page 2 on the bottom left? The natural gas agreement details.
Yes.
Same thing. There's a row, right to cancel, rescind, and an explanation of the 3-day right to rescission. Do you agree with that?
Yes.
The next page, electricity agreement details. Same thing, right to cancel, rescind, and then a description of the 3-day right to rescind.
Yes.
One moment, please. And then I believe it's in the terms and conditions, but I can't put my finger on it, so we'll go right to the end on page 10, what is marked as page 10.
I see it.
Do you see that in the all cap, bold, the consumer's right to cancellation?
Yes.
Okay, and that's the 3-day rescission there in near proximity to the signature?
Yes.
Okay. Or I should say immediate proximity, because I believe that's the statute, that's the language you used. Did you agree with that? I think in line 8 and 9 in your testimony, you say a statement which is in immediate proximity. And I believe I said near proximity. I should have said immediate. Would you agree that this is on page 10 is in immediate proximity to the signature?
It would appear to be in proximity.
Okay. And then the next 2 pages, which are marked 11 and 12, those are the notice of cancellation, which are handed to the customer at the door, correct?
Yes.
And that also advises the customer of the 3-day right to rescind? It's the first bullet point. The first.
Yes.
sentence. Yes, okay.
Yeah.
All right. And are you aware whether the 3-day right to rescind is included in the ETPV or TPV that SFE requires of its enrollees?
I can't recall.
Okay, fair enough. Okay, and then the next part of your testimony is, let's go down to line 14. You quote from a CAD decision about a Maryland Telephone Solicitations Act violation. Do you see that?
Could you repeat which line again?
Well, you start discussing it on, I believe, line 14, in complaint number 000348853, and then to the end of the page.
Yeah. Yes.
Okay. Are you aware that that particular customer is a commercial customer?
Yes.
And do you know?
Just to be clear, yes, you're aware, or yes, this is a business customer?
I am aware.
You are aware that this complaint involved a complaint made by a business customer? Are we saying the same thing?
I'd like to get this clear because I'm not clear. Mr. Herbert, the question is with respect to this statement, line 16 through line 29. Do you know if this is with respect, this complaint 34853 is with respect to a business customer or a residential customer? Do you know or do you not know?
I can't verify precisely at the moment.
Okay, so let the record reflect the witness does not know.
Okay. Without asking for your legal opinion, do you know whether the Maryland Telephone Solicitations Act applies to sales made to non-residential customers?
Yes.
You believe it does apply?
Or
Would you agree with me that the MTSA does, in a non-legal opinion of yours, do you agree with me the MTSA does not apply to sales made to commercial customers?
I'm uncertain.
Okay. All right. The next page. Sorry, page 12. The customer-initiated drops. You say, is staff maintaining that there's a pattern in practice of customer-initiated drops that are not properly processed by the company? Or is it just one instance?
So in page 2, the testimony states
Mr. Herbert, page 2 of your testimony?
yes,
What line?
4. false and misleading information about the company's rates and business affiliations, unauthorized enrollment without consent, and providing inadequate information to allow the customer to make an informed choice. So for the customer-initiated drops, I couldn't say for certain whether there's a pattern or not there.
All right, he answered your question.
That's all the questions I have, Your Honor. Thank you, Mr. Herbert.
Thank you.
Thank you. Do the commissioners have questions of this witness? I'll start. Mr. Auslander asked you how you calculated your proposed penalty of $400,000 for the alleged violations of statute and law. You said you consulted with the statute, looking at the mitigating factors and any good faith efforts by the supplier to reform its activities and operations. Can you give any additional specificity as to how you determined the calculation of $400,000 in this case?
Sure. So, $400,000. First of all, considered the number of the violations determined by CAD at 46. And the law says up to $10,000 per violation.
So that would get you to $460,000?
So
simple math?
So that would get, and I ran this calculation previously. I think that comes out to about in the neighborhood of $680K, and then I considered the good faith efforts made by SFE to reform its materials, and that's a drop of a few $100,000. And then finally, I also considered commission precedent, and it appears that $400,000 is also in the neighborhood of what the commission has done in the past.
Thank you, Commissioner Bubar. And Mr. Davis, you'll have an opportunity to have redirect of your witness. The other two counsel will have the opportunity to ask any follow-up questions based on commissioner questioning.
So I wanted to better understand, so SFE Exhibit 2C, which we have all been looking at, which Mr. Green offered, related to complaint 000-35938, which is in your footnote, number 10, on page 10 of your testimony. But you also go on to say, in lines 13 through, I guess, on to the next page, you cite what CAD had found, that the documents titled The Electricity Agreement Details, which I think are page 3 in SFE Exhibit 2C, mirroring the contract summary form may not be used as the supplier's contract. And then also the document entitled Terms and Conditions is not in itself a contract, and you go on to note that the terms and conditions, this contract does not include all the material terms and conditions outlined in 20.53.07.08A of the regulations. And so I'm trying to understand this, all of these materials that were in Exhibit 2C, the line of questioning that we just went through, how does that compare with what you stated, Mr. Herbert, on page 10 and on to page 11, where you note that CAD did find that there were issues associated with some of these materials that are in this exhibit, particularly related to not being in compliance with the regulations?
Yeah, so lines 13 through 17 say documents titled, CAD's findings note documents titled electricity agreement details, which is in, I think, yeah, page 3 of this exhibit, and then also terms and conditions. Oh, I found it. Page 4. Neither of these, CAD did not find that any of these from this finding satisfy a contract. And so the what CAD determines in these complaints is the terms and materials and conditions must be present in the contract itself, rather than I guess supplement documents such as the contract summary and another document entitled terms and conditions. It would need to qualify as a contract and have all the terms and conditions within the contract. That is to say, my understanding is that if it's a document that has all the terms and conditions that a contract should have, but it's not actually it doesn't count as a contract, that isn't fair game for an enrollment. Or if there is a document that CAD determines does suffice as a contract, however, it doesn't have all of the terms and conditions that are required, either one of those two paths could warrant CAD ruling the enrollment as invalid.
Okay, thank you. And then I just have two other questions. I don't want to put words in your mouth, but I think you note that there was some improvement in the number of complaints. I had your site, but I don't have it in front of me right now. But then the trend kind of went negative again. And I was just wondering if maybe you could expand on that a little bit. And maybe if I could find the exact statement in your testimony. But you talk about how things did improve, but then they didn't after that. I'm sorry, do you recall?
It's on page 13.
Okay, thank you.
Yeah, so
Yes, thank you. You say on line 4 through 7 on page 13, there was a steady decline in complaint numbers between January 2021 and May 2021. But and you said that, but then CAD went from receiving 16 complaints in January 2021 to 1 complaint in May. This would indicate that SFE experienced improvements in the raw numbers. However, between May of 2021 and September 22, there was a series of oscillations that suggest instability remains in complaints numbers.
yes, so that comes from there's a sheet within staff exhibit CAH1 that analyzes the sort of movement of complaint numbers over time, and the exhibit is confidential mainly because of customer in specific information is within the sheet. But as to the details of that graph, yes, it shows that from between May and September, the complaint numbers sort of move up and down very rapidly. So the oscillations are referring to the revolutions of going up and down several times. And so that to me was, even without using any regressions or techniques of that nature, the movement of the complaints seemed to suggest that the numbers and the company's ability to contain complaints was unstable.
Okay, thank you. And then I just have a final question, which, if this isn't appropriate, let me know, Chairman. But if the commission does adopt the staff, your recommendation to revoke their license, what would happen to the customers that are currently being served by SFE?
If you know, Mr. Herbert.
They would be moved back to the utility.
Okay, thank you. That's all my questions. Thank you.
Commissioner Linton.
Thank you, Mr. Chairman, and good afternoon.
Afternoon.
Just a couple of questions, just so that I can understand a couple things. You testified here today and in your pre-file testimony that there were 42 customer complaints that you use as the basis for the violations of COMAR against SFE. Could you tell me the current status of those particular customer accounts? Are they still with SFE? Are they still pending at the commission? What's the current status of them?
I'm not sure as to the status of all of those.
Okay. Do you know if they have they been reimbursed? Have they been returned to SOS? Are they still with SFE?
I'm also unsure if re-rates have been issued yet, and if they've been all been transferred.
Okay. Could you describe, well, let me ask a different way. As part of your investigation, were you seeking additional information from the company beyond what the company already provided to CAD?
We did not in this analysis. No, I didn't.
Okay, so no data requests, it was exclusively a review of the information that SFE provided to CAD.
This information takes into account the information that's provided by CAD.
Okay. Part of your recommendations, you recommended a moratorium, and this is on page 16 of your public testimony. Starting at line 6 is where the question is. There in your answer, you recommended a moratorium on new customers and any marketing for 5 years.
Yes.
So that I'm clear, when you say a moratorium on new customers, you mean enrolling any new customers beyond the ones they have currently?
Yes.
Okay, and marketing meaning, of course, that they can't attempt to attract any new customers.
Yeah.
For 5 years.
That's right.
For the customers that they have currently, since you recommend suspending the license, as you responded to Commissioner Bubar, that would also mean they would return to SOS.
Yes.
So effectively, the company would have no license and no consumers in the state. under your recommendation?
Yeah.
Okay, this is if they, well, if they're licensed, they would have, let me clarify for the record. Your suggestion is that if they remain licensed, they have no new customers and cannot attract new customers.
Correct. Yeah.
So if they remain licensed, do they keep the current customers they have currently?
Yeah. If they keep the license, they would keep the customers that they do have now, but they wouldn't be able to expand.
Okay. All right. Could you tell me what the basis is for 5 years for a moratorium on new customers or marketing for 5 years as opposed to 4 years or 6 years? What's the justification for 5?
So 5 years seemed to be severe enough that it would cause the company to take a at all costs approach to remediating their measures even further to make them robust enough to not have complaints coming in like this. It's been shown both in the testimony and in the charts in Exhibit CAH1. They would prioritize stability, but it would obviously be temporary. So the company, after 5 years, presumably would be able to come back and have a revamped approach.
Okay. All right. Thank you. That's all I had. Thank you, Mr.
Sure.
Chairman.
Commissioner Richard.
Thank you, Mr. Chairman, and thank you for your testimony today. And I just want to, talk about a lot of different things here. And I just get back to what I think was meant to be the core of your testimony, and that is you looked at a number of complaints and found that there were some common issues of misrepresentation by the salesperson. Is
Yes.
that correct?
That's
okay. And it was. Can you maybe just describe some of those specifics about where there were representations by the door-to-door, salesperson? And I think where you went with that is that there's a pattern that, obviously it's not, company gets mulligans and things like that. If there's an infraction, there's an infraction, and if there's a pattern of infractions, then we need to be concerned. Am I reading your testimony correctly? And maybe you want to talk a little bit about some of those patterns.
Yes, and I will expand. Specifically with regard to the misrepresentations, on page 7, there's a chart that outlines several of the misrepresentation complaints that had to do with the supplier agents saying that they worked for another entity. And two of those, the one is complaint number 32379, where the agent said that they were with BGE and that they were there to their pitch to as the customer alleged was that they were there to fix improper billing overcharge by BGE, as in they were a BGE employee that was coming in to fix one of BGE's own issues. And the evidence that they provided, as the customer alleged, was that there were codes, special codes that were on the BGE statements that specified this issue. And the agent, as a supposed BGE employee, said, your code, there's something off about your codes, so you're being overcharged, we're going to fix it. And that was the premise of signing documents that in actuality were would have been SFE. Another complaint, 32496, says nearly that, and I believe the testimony apportions those two complaints in back-to-back rows, so one is over the other, and so it's easy to see that these are close to being identical situations. The only difference is in 32496, the agent said they were a contracted adjuster for BGE rather than specifically like I guess a primary BGE field person, contracted adjuster. But it's the same exact story, and looking at this, I'm hard pressed to say that, two customers who, have no reason to suspect know each other or have met before, specify exactly the same pitch for there being a issue from BGE, the same identity of the agent, Baltimore Gas and Electric, and also the most striking thing to me is these codes. They both assert that there's codes that are specifying that there's an overcharge or issue, and I'm very hard pressed to say that that's just coincidental, that they came up with exactly the same identity, assertion or pitch from the agent, and also the same exact justification for the issue that they're supposedly present to fix.
Great, thank you for that clarification. And then I think on page 5, line 18, you talk about there are multiple allegations of representations about guaranteed savings, implied guaranteed savings. So there was a pattern of people coming to the door saying they're guaranteed savings. So despite what happened later in papers and the things that we spent a lot of time on just now, there was a discrepancy between what was told to the individual at the door and what maybe they were left and possibly confused by another step in the process. Is that one of the things that you're trying to bring our attention to with your testimony?
Yes. It seemed to be that there were instances where the customer seemed to have been under the premise that this is, and several I guess admin meetings have alluded to the fact that utility bills get expensive, and a lot of customers, if they see someone who is offering a chance to lessen the cost of their electricity, their gas, it's a very strong incentive to look for that way out of very expensive bills, and so it seemed, based on my review of the complaints, that I'm asserting that there seems to be an appearance of customers are enrolling with SFE under the pretense that they're going to save money on their bills, and then they complain and they're surprised about the fact that they didn't, and they seem to indicate that that they wouldn't have signed up for SFE if they knew that the bills were going to, such as in 26725, which is quoted in the testimony, $77.43 more than usual.
Okay. All right, well, I think that helps. And just a final question. So you were focusing really between January 1st, 2020 and September 30, 2022. And it was during this period of time there was these encounters by door-to-door sales folks where these misrepresentations took place. And this is where your focus on these trends, these patterns. Is that correct?
Yes.
Okay. Thank you. Thank you, Mr. Chairman.
Thank you. We'll allow, if SFE or if OPC has any questions based on the commissioner questioning, you'll have an opportunity for some limited redirect, and then Mr. Davis, you'll bat clean up. Anything, Mr. Auslander, Mr. Green?
I don't have anything, Your Honor.
I think I can do it in two questions.
Okay. Based on which commissioner?
Commissioner Bubar's questions. If you could turn to page 13, please. The Commissioner Bubar asked you a question about the complaint statistics you have here in lines 4 through 12. Do you recall that?
Yes.
And my question is, these look at the complaint dates when the complaints were actually filed, correct? Not when the customer actually enrolled with SFE. Is that right?
Yeah, these are based on the complaint open dates.
And the open date is when CAD opens the file?
Yes.
Okay. And then the next question is, Commissioner Bubar asked you about the exhibit SFE 2C, and you know, the contract summary, whether it's a contract or not. I'm paraphrasing. And in your review of the CAD complaints, would you agree with me that this is an issue that CAD began noting in its decisions in approximately at some point in 2022, early 2022 for SFE? Do you recall?
I'm not entirely certain.
Okay, but you would agree with me that throughout 2020 and 2021, CAD was issuing certain decisions in favor of SFE and not citing any concerns about the contract.
It did appear, based on my review of the complaint data, that the contract issues came later, or the CAD ruling in favor of the contract came afterward.
Okay, and when you say afterwards, you're talking about at some point in 2022? Is that fair?
Yeah.
Okay, thank you, Your Honor. That's all the questions I have.
Mr. Davis.
Thank you. Just for clarity's sake, in response to Commissioner Linton's question about data requests, did you review any of the data requests that were sent by staff to SFE in your preparation of this testimony and for your preparation of this hearing?
I did review them, yes.
Okay. And then I was also, so are you, in your testimony clarifies that there were 46 complaints filed against SFE that were resolved in favor of the customers, is correct?
Resolved in favor of the customers and included in the staff complaint.
All right, thank you. And so, in your experience, how many complaints would you deem acceptable as a staff member of the commission?
The staff of the EEP division of the commission, we're concerned about any complaint, and so we would take any presence of complaints worth investigating and seeing if there are issues, and certainly the commission's website makes public complaints. Any company that is north, either on or north of 3 complaints per month, and I would consider 3 or more complaints per month to be unacceptable.
Okay. And to that extent, when you are reviewing these complaints, do you consider whether or not they're resolved in favor of the customer or in favor of the company?
Yes, so that is a consideration that is made. The 46 complaints that are referenced using the that were also in the CAD in the staff complaint were in favor of the customer. Complaints that are rendered in favor of the company are not ignored. They're still considered to the extent that the allegations may show commonality with allegations of were made in complaints that were rendered in favor of the customer. Now we don't assert that the CAD found a present. There appears to be violations in complaints that are in favor of the company. Of course, not that, but they do present at least more material to look at in terms of issues that the company may be facing in terms of its compliance.
Okay.
Your Honor, I have to object. He's materially expanding and altering his testimony.
You objected a little late, Mr. Green. He just answered.
He just testified, first of all, twice that there were 46 complaints in favor of the customer, and that is not correct. There were 15 out of 46 total with concerning misrepresentations.
Well, his testimony is on the record now. If you'd like to amend it, he can amend it,
Then-
but he was finished with his response.
I would ask that that answer be stricken then.
I
It is-
can amend the question to be more I'm specifically referring to the entirety of the complaints that were noted in Mr. Herbert's testimony.
Your Honor, his testimony and his analysis and his written and live testimony today is that his conclusion on misrepresentations is based, he reaches a pattern conclusion based on 15 of the 46 complaints. And now he's seeking to go beyond that to say that even the ones in favor of the customer support his position. And that is not in his testimony, and that's not what he said this morning.
So first, the question was not about misrepresentation specifically. The question was generally about the totality of the testimony, which includes the 46 total complaints that were resolved in favor of the customer, as well as 136 complaints that were resolved in general against SFE during the review period.
Mr. Herbert, is your testimony based on the more limited number of, is it 15? 15?
Yes.
Or the 46 complaints?
The analysis uses for misrepresentation the 15 that are in favor of the customer.
Okay.
Yeah.
Okay. Any more redirect, Mr. Davis?
No, I believe that's it.
All right, we'll take a lunch recess at this time. We'll reconvene at 2 p.m. Mr. Herbert, you're excused for now. You're not released for the day, so be available. Witnesses are not to have any conversations with their attorneys during the lunch recess. Mr. Davis?
Yeah, may I amend Staff Exhibit 1 to Staff Exhibit 1 Public and Staff Exhibit 1C Confidential?
Yes, so marked and noted. Sorry, Mr. Green, yes, you may confer with your witness.
Okay, thank you.
We're not in the middle of witness testimony.
And is it accepted into evidence, the change?
I learned that lesson the hard way a long time ago, marking something but not moving it into evidence. Staff Exhibits 1 and 1C are moved into evidence.
And while we're in that, can we check on, I know Exhibit 1C, and I want to make sure that SFE 2C was entered as well.
I believe I moved it into evidence. It was, yes.
Thank you.
Okay, anything before we break for lunch? Okay, we're in recess until 2 p.m. We are back on the record in case number 9690. Mr. Green, you may call your witness.
Your Honor, before I do that, respectfully, given the staff testimony this morning, we think it's appropriate to renew our motion to dismiss. The evidence against the company failed to raise a pattern or practice of any of the allegations, no, certainly not misrepresentations, given that the staff only considered the 46 total misrepresentation allegations and only 15 went against the company, whereas the evidence reflects that 26 went for the company. The unauthorized, and that is clearly not a big enough pool to tell that there's a pattern or not. So they've failed that test. Second is the unauthorized enrollment. The evidence reflects that the company has addressed that with respect to the account holder, ensuring that the account holder's name is on the enrollment, and that most of those CAD decisions of on unauthorized enrollment involved the enrollment of non-account holders. And then lastly, on the contracts issue, the evidence shows that this is a 2022 issue, that up until 2022, the company was receiving CAD decisions that made no mention of any contract issue. So on top of that, the CAD decisions that are in evidence is the decisions that came out, one in November of 2022, one in December of 2022, one was commercial, one was residential, reflect that the contract situation has been resolved. So those were decisions in favor of the company and valid enrollments. The cancellation notice that Mr. Herbert cited on the contract, as the contract we looked at indicates, that has been resolved, that has been cured. The cancellation notice, as he testified, is in immediate proximity to the signature. And the MTSA issue that he cites to one, I believe he cited to one, is a commercial customer, and the commercial, I think we can, as a matter
Have
of-
we established that it's a commercial customer?
It's in the record. There is a CAD decision in the record that shows it's a commercial customer. It has been entered as staff's testimony. And then that is a commercial customer, and I think as a matter of law, we can acknowledge that the Maryland Telephone Solicitations Act applies to consumer goods, which are goods used in the household, and that is not this. It does not apply to non-residential sales. So when you, and then finally also with the issue of drops, there's certainly no pattern there. There was only one identified CAD decision. That had its own, actually, kind of eccentric facts to it, but there was only one decision. And that's certainly not a pattern. It's certainly not something that warrants the Commission's attention. It has been dealt with at CAD. So when you add all that up, we would renew our motion to dismiss and ask that judgment be entered in favor of the company and dismiss the staff's complaint.
Thank you. Your request for a renewed motion of dismissal is denied based on the evidence that the commission has heard to date. There is an open question as to whether violations and misrepresentations, including violations of both statute and regulation, continue to exist, albeit some concessions were made by the witness on the stand. So this show cause hearing will continue, and you may call your next witness.
Thank you, Your Honor. SFE calls Mr. Jeff Donnelly.
Mr. Donnelly, if you could please raise your right hand and remain standing.
Do you solemnly affirm the penalties of perjury that the statements made in this matter today are the truth, the whole truth, and nothing but the truth?
I do so swear.
Finish your full name.
It's Jeff Donnelly. Last name is spelled Donnelly.
And can you give me your business address, please?
Sure. It's 100 Milverton Drive, City of Mississauga, Ontario, Canada.
You gotta speak.
Oh, sure. Sorry. Sorry.
Give me spell your last name for me again.
Sure. Donnelly. Business address is 100 Milverton Drive in the City of Mississauga, Province of Ontario, Canada.
Thank you very much.
Thank you.
Mr. Green, you may begin.
Just let him sit down. Mr. Donnelly, by whom are you employed,
I'm employed by SFE Energy.
and what's your job title?
I'm Vice President of Regulatory Affairs and Compliance.
And can you tell the commission what that entails?
Sure, I'm responsible for oversight of all legal and regulatory matters for the corporation and its entities, including oversight of the compliance team responsible for handling commission complaints and consumer inquiries and complaints.
Okay. And can you briefly discuss your work background and your education, please?
Sure. So I started off my career in policing 23 years ago. After 6 years of policing, I had worked in various management positions, including as provincial prosecutor in Ontario. The management positions I had worked in were for several regulators in Ontario, similar to what the commission staff does with CAD. Then I eventually came to work for SFE. Education-wise, I hold a master's in administrative law, as well as a postgraduate certificate in commercial mediation and negotiation, postgraduate certificate in adjudication, and I sit as a part-time commissioner of several regulators in Ontario presently.
Can you explain that last part?
I sit as part-time commissioner for several regulators in Ontario.
Right. Can you explain that? What does it mean?
Sure. So in Ontario, the scheme's a little bit different. There's a full-time commissioner, and then there's part-time commissioners. So I sit as a part-time commissioner adjudicating over matters similar to this with consumer inquiries and complaints, where commission staff bring forward matters such as this for adjudication and decision.
Okay. Thank you. Let's talk about SFE. Can you tell us about SFE's history in Maryland?
Sure. SFE was licensed in 2013. That's excuse me, right around the time that I was employed by SFE is when they obtained their license in Maryland.
And was that for electricity and gas?
That's correct.
Okay. And can you talk about their customer count, their enrollments? Generally, what's your understanding of what the current customer count is in Maryland, and then we'll talk about the marketing channels.
Sure. Yeah, the current customer count's approximately 29,000. We're talking about residential customers.
And of those 29,000, can you talk about the marketing channels and how they are enrolled? Or the marketing channel and how many customers are enrolled by each marketing channel?
Sure, I don't have the specifics in front of me of how many customers for each marketing channel, but we utilize door-to-door sales for residential sales. We utilize commercial brokers to conduct commercial sales on our behalf. We also use our internal customer service team, essentially just for dealing with customer inquiries and customer retention methods. We don't per se have any online presence, but we do conduct, obviously, what we refer to as win-backs with customers that have either dropped off with the utility or had called in to cancel, and then we'll conduct a process of reminding them of the contractual obligations that they have, and then let them make an informed decision about whether they want to proceed with cancellation or not.
Okay. All right, Matt. Your Honor, I'd ask that the document being circulated be marked as SFE 3, and it is not confidential.
So marked as SFE 3.
Mr. Donnelly, do you recognize this document that's marked as SFE 3?
Yes, this is a customer database count for SFE from January of 2020 to end of September 2022.
Okay, so these are the number of customers per month or the number of enrollments per month?
This is the number of enrollments per month.
Okay, so the total at the bottom right of 46,946 since January of 2020, that's not the current customer count, correct?
Correct.
So that's the total number of, sorry. That's the total number of customers that have enrolled with SFE since January 2020.
That's correct.
Okay. And is this commercial and residential, or is this just residential?
I believe it's aggregate.
Okay. Your Honor, I'd ask this be entered as SFE 3.
Seeing no objection, SFE 3 is moved into evidence.
Do you recall, Mr. Donnelly, how many of the current 29,000 customers are enrolled by the door-to-door channel?
I'm not too sure on the exact number, but it would be the majority of those customers would be door-to-door.
Okay, if I were to tell you about 25,000, would you agree with that?
That would be about accurate, yes, correct.
Before we go further on residential, can you please tell me how the company enrolls commercial customers in Maryland?
Sure. Commercial customers, we utilize licensed commercial brokers in the state of Maryland. They conduct sales, whether it be in person with consumers, or they also conduct telemarketing calls with commercial consumers as well.
And those brokers, are they selling only for SFE?
No, they're not. They sell SFE products and they sell other competitor products as well.
And to your knowledge, are they licensed with the commission to be a broker?
Yes.
Okay. And for residential, I'm trying to streamline some things. So for residential, you would agree that the door-to-door channel can result in numerous complaints if not done properly, correct?
Correct.
And even if done properly, it can still result in complaints, right?
Most definitely.
Okay. So can you describe the training that the company does with its vendors and the individual agents to educate them about how to properly sell?
Sure. It starts with the onboarding of the vendor themselves. So once we've come to an agreement with the vendor to provide door-to-door services on behalf of our company, we'll conduct initial training and onboarding with the vendor and their management team. That includes a rigorous training presentation and process testing with the vendor as well too, as well as ensuring that they have received access to our portal, know how to order the proper identifiable clothing for their sales representatives, and also are fully aware and understand the rules, not just of the COMAR in Maryland, but also of our additional consumer protection provisions that we put in place as a policy within the company. Once that is completed, the vendor is responsible for the hiring and recruitment of their own sales force. They'll conduct the training with the sales force. The sales force is required to do a test after they completed the training. The test is provided and administered by the vendor, but the answer key is provided to SFE's compliance team. Compliance team is responsible for marking that answer key, for which the vendor does not know what the answer is because we change it up on a regular basis. Each sales rep is required to achieve at least an 80% on the test in order to qualify to be able to sell SFE products for that vendor. If they fail the test, they're given an opportunity to rewrite it once and once only. After they've completed the test, they've got a requirement obviously to wear identifiable clothing, whether that be a hat, buttons, required lanyard that has SFE logo on the lanyard itself. There is a badge that the sales rep has to have with them. It's a photo ID badge of themselves. It contains SFE Energy's logo. It also contains the rep's name and unique identifiable ID number, as well as the vendor's corporate entity name as well, and both our gas and electricity licenses with the Public Service Commission here in Maryland. Sorry, Commissioner, you mind if I steal that tissue? Thank you.
Your Honor, I'd ask that this be marked as SFE 4. It says confidential. It is not confidential.
So marked.
Mr. Donnelly, do you recognize the document that has been marked SFE 4?
Yes, this appears to be our current training presentation
So
for
this
residential sales. Sorry.
is this the document that goes to the vendors for training purposes?
That's correct.
Okay. And I'm not going to go through it all, but does it cover misrepresentations?
Yes, it does.
And how about, does it instruct agents to only enroll the account holder?
Yes, it does.
And does it warn against slamming and unauthorized enrollments?
Yes, it does.
Does it have Maryland-specific issues in there with respect to door-to-door requirements and so forth?
Yes, it does.
Okay. Your Honor, I'd ask that the SFE4 be entered as SFE4.
Seeing no objection, SFE4 is moved into evidence.
We would object that this PowerPoint is outside the scope of the review period that was identified in staff's complaint.
You were a little slow on the objection, Mr. Davis. Mr. Green, how would you respond?
Well,
It is dated January 2023.
It's already in, so we can't take it out, but I can ask the witness more questions about it.
The commission could give it the weight that it's due. I already see on the first page it says most people are potential customers, and the witness has already stated that it's account holders. So we'll SFE 4 remains in evidence. The objection was late. Mr. Green.
So does the training stop with the test?
No, it does not.
Okay. Is there retraining? Is there disciplinary actions that are potentially taken? Can you comment on that, please?
Sure, yes. We have an internal policy and a well-developed oversight process for the sales representatives, which includes looking at complaints, including CAD complaints and internal consumer complaints that we receive or inquiries. Sales representatives are monitored based on a complaint to contract signed ratio process. If we identify any trends or potential issues, we will issue retraining to the individual sales rep. That would comprise of issuing of a compliance notice requiring the retraining. In most instances, the sales rep may be placed on suspension until the retraining is complete, or they'll be given a minimum time frame, for example, say 5 business days to complete the training. If you don't complete the training within that period, then you'll be suspended until such time that you do complete the training. We also have an in-field compliance officer that attends the vendor's office, does field shadowing with the sales representatives, and provides additional training based on what we may see as potential trends or potential issues, just so we can stay on top of it and make sure the sales representatives are well informed. As I'm sure everybody can appreciate, we're talking about individuals conducting door-to-door sales, not necessarily always the most sophisticated individuals, and sometimes retraining is required just to remind them of their obligations and the rules within the state of Maryland.
And how many vendors does SFE have working in Maryland for door-to-door?
Just one.
And has it ever had more than one?
It's had additional vendors in the past, but primarily the services provided on door-to-door in Maryland for SFE has been conducted by one vendor.
Okay. Now's probably a good time to ask this line of questioning. So there's an allegation in this case that once the statewide proposed order became final in January 2022, do you recall that?
Yes, I do.
That statewide, rather than do a compliance plan, just shifted all of its operations over to SFE. Do you recall that allegation?
Yes, I do.
And how do you respond to that?
It's simply not true.
Why do you say that?
Because we continue to enroll on average 25,000 customers each year from 2016 until present.
So can I direct your attention to SFE 3, please? So the customer
Okay.
count.
Thank you. Yes.
So am I correct that the statewide order came out in January of 2022, correct? Is that right?
That's correct.
Right. So if Statewise had shifted all of its operations over to SFE, would you expect that the numbers for enrollments would have increased beyond certainly what they would have been in 2021?
Yes.
And based on this chart, do they?
No.
Did SFE hire an additional vendor?
No.
Did SFE instruct the one vendor to ramp up activities anywhere in Maryland?
No.
So is it your testimony that SFE just continued on normal business operations before, during, and after the statewide proceeding?
That's correct.
Okay, let's can you describe for the commission SFE's enrollment process for door-to-door?
Sure. So SFE's enrollment process, primarily if we're just focusing on the paperless process, the sales rep will attend the customer's residence. They'll be wearing their lanyard and their identification badge. They'll also have business cards in their possession that are printed on both sides. One side of the business card has a placeholder for the agent's name, and as well as contact information for SFE. Flip the business card over. On the back side of the business card, it clearly states that SFE Energy is not the utility. The customer or the sales representative is required to present that to the customer at the immediate point of approaching the customer's door and having interaction with the customer. Then obviously the sales representative will begin their sales solicitation process. They will have brochures that they can present to customers that are generic. They don't contain pricing information. It's just fairly generic brochure. They will present the product offering to the customer on their tablet device. The customer has an opportunity to either A, choose touchless, meaning that the information that's being put on the sales representative tablet device will be transferred to the customer's phone via text. So the customer then could complete the review of the contract information, scroll all the way through the terms and conditions, click accept in order to get to the place of when they sign the contract itself.
Wait, can I stop you? I'm sorry.
Sure.
I meant to kind of give an overview.
Sure,
We
sure.
Let me pass this out.
Sure.
I thought the witness was giving an overview. Let's see what we have here.
This might help to streamline and to keep it focused. And
So-
Staff would object to this also on the fact that it is outside the review period. This says March 2023.
Okay.
uh,
Your objections are coming early now, but I guess better early than late. Mr. Green.
so this document was attached to the reply comments that SFE filed on Monday, March 20th, 2023. It was Exhibit 1 to those reply comments. That's why it's dated. That's why it has that date on it. So,
The
but
commission received this on March 20th.
correct.
Okay.
Yes. And,
All right.
uh,
Mr. Hunter Davis.
I would still submit that there's no date on these then, so there's no verification of when this type of form was provided to customers and which customers saw this form, or, it's obviously this is online for online customers, but
Yeah.
when?
Let's hear that from the witness, and then when it comes time to rule on whether this is to be part of the record, we'll have your objection ready.
All right, thank you.
I guess I should ask that it be marked as SFE 5.
Correct, 5, so marked,
It is public.
public.
Okay. Okay, so before we dive into this, Mr. Donnelly, is it fair to say that there's roughly a 4-part process to enrollments for SFE door-to-door?
Yes, that's correct.
Right. And what are those for?
Sure. Step one is the presentation of the contract to the customer and execution of the contract. Step two would be an ETPV, so a verification that is transmitted to the customer's own device that they complete on their own device. Several questions, including verifying that the individual didn't represent themselves as being from the utility or any other supplier. Also that savings are not guaranteed, as well as that the representative presented a business card at the immediate onset of the beginning of the solicitation, and including requiring the customer to, if it's a live TPV, read backside of the business card on that TPV, which I previously said it states SFE is not the utility. If the customer is able to get through the contract signing and the completion of the ETPV, then there's a live quality assurance call that happens to the customer. On that live quality assurance call, again, the customer is asked to read the business card and to affirm that the sales representative did not make representations about being from the utility or any other supplier. If they're able to get through the series of questions on the quality assurance call, then what happens on the back end after we receive the contract enrollment information, our operations team will check the EDI transactional records with the utility and confirm that the name on the contract for which the customer has already indicated 3 separate occasions that they are the account holder of record. We're confirming that on the back end as well with the operations team in the EDI transaction that in fact is the case.
And that last part is what went into effect in when?
Between December and January as a result of the statewide settlement and subsequent order.
2021, 2022?
Correct, yes.
Okay. So let's turn to SFE 5, and if you could walk us through what are we looking at, and why don't you walk us through it?
Sure. So these are screenshots of the sign-up process that would be on the sales representative's tablet. The process, as far as the screenshots and the steps, haven't changed over the years that we've been using it. So it starts obviously with the sales rep having to put in their office ID and rep number, same number that's on the sales rep's badge. Then they'll have an opportunity to put the customer's information in. This information is gathered after the customer's already indicated a willingness to move forward with the potential product offering. Then the customer is provided their details on the product term and information in regards to the enrollment for the fixed price product. We only offer fixed price products to residential customers. Then the next screen on the following page, as you can see, references the ability for signature options, whether it's going to be touchless or on the sales representative's device. So as I previously stated, that's the customer's choice. And then once that's selected, then the customer either executes the signature on their device or on the sales rep device, but not until such point that they've scrolled through the entire terms and conditions and selected the acknowledgement button to accept. That's the only point in which they're able to sign it after that point.
Okay, what page are you on now?
I am just getting, I'm trying to see the page numbers. Oh, sorry, yeah. 6 of 17.
Okay.
So this is just another screenshot of putting in the customer's information, email address, phone number, whether the touchless consent is for SMS or sent to an email. And then there's a screenshot on page 7 of 17 that identifies the message that the customer would get on their an SMS mobile text, if that's what they opted to select.
So I'm sorry, where is the customer in the process now? Have they?
Right now in this process from 7 to 17 is they've selected to receive the information to their own device. They're going to proceed with reviewing the contract terms, which then is over on page 8 of 17. So after the information's been inputted with the customer-specific information, then all the details appear in relation to the contract terms, for the customer to review and consider. And then over to page 9 of 17, this is the part that I was mentioning earlier about the requirement to have to scroll through the terms and conditions. So if you see on top of 9 of 17, there's a little toggle button, no different than you would use if you're looking at a Word document or a PDF on your computer. The customer physically has to scroll through that entire thing in order for it to be allowed them to hit the I agree button and then sign it with their finger. So all the required disclosures are on that page as well. And then after they've signed and completed, they'll get a message enrollment is complete. And then these additional screenshots, I believe is just the alternative of it being on the sales rep's device. So if the customer selects not to be touchless onto their own device, then these are the screenshots that the customer would see on the sales representative's tablet. So that would include page 11 of 17. And then 12 of 17 just identifies, so after the sales transaction is complete and the customers agree to all the terms, they scrolled through, they've signed, an email goes to the customer immediately. That email, this is a sample of what you're seeing here on page 12 of 17. Thank you, welcome to SFE. There's 2 PDF documents you can see that are in the subject component of the email. The one PDF document is just the contract summaries standalone as one PDF. The second PDF document is the complete contract terms and including the customer's signature. So that all happens. Once that's complete, then the customer will receive another SMS message to complete the eTPV. This is when the customer selects on the link to complete.
Let me just stop you
Sure.
real fast. Is it your understanding that once the customer signs the contract and receives the contracting documents, SFE has satisfied the minimum requirements in Maryland for enrolling a door-to-door customer?
Yes, that's correct.
Okay, so long as the contracts have all the things in it that they're supposed to have, right?
That's correct.
Okay, all right. So now we're on page 13?
Yes, 13 of 17. So as explained with the 4-step process earlier, the customer will receive this eTPV. They'll click on the link, and this is what will appear. Series of questions. The customer response has to be yes to all of them. If the customer does not respond yes to all of these questions, the enrollment will be declined and won't proceed further. After they have responded yes to all of these questions, they also have to sign again on the eTPV to acknowledge that they completed it. And then once that's completed, that'll queue up a quality assurance call, a live quality assurance call with a live individual to the customer. So if you turn over to page 14 of 17, this is the QA script that's used, and as you can see, we have additional questions on the QA script, including, as I mentioned earlier, having to read back the business card confirming that SFE Energy is not the utility. If the customer cannot answer these questions, the QA call will be rejected, and the enrollment will be declined, and the sale is concluded at that point and will not be processed. And then page 15 of 17 is the other option of just conducting a live TPV, which is essentially the same questions that are on the eTPV, but it's conducted live with a live representative that's a third-party independent representative, independent both from SFE and independent from the vendor themselves, and they complete this live TPV with the customer.
So, quick question. When the company receives a CAD complaint and it responds, what does it typically send back to CAD?
We send all of these documents.
So you have a copy of the contracting documents, the completed TPV, And do you record the quality assurance call?
That's correct.
And you send that
That's correct.
to CAD?
To CAD, yes.
Okay. All right. Keep going.
So page 16 of 17 is just going through more of the contractual terms. So it's essentially a regurgitation of everything that they reviewed on the tablet or on their own device and already had agreed to. The customers then, it's queued up again for just to go over all the contractual terms and everything. And basically this creates a placeholder for the customer if they have a question or something pops up and it appears the customer's not quite understanding, then the third-party vendor has the ability to decline the live TPV as well.
Does the company track how many people get through the contract but not the TPV, and how many get through the TPV but not the QA call?
Yes,
And-
we do.
Your Honor, I'd ask that this document be marked as SFE 6, and it is public.
This is a two-page document, it appears.
One-page document.
One page. I have lots of different pages here.
And I haven't, I must have grabbed my approach and figured out for you.
Yes. Oh, there's a blue page. That's probably yours. Okay, we'll mark this document as SFE number 6.
Mr. Donnelly, in looking, do you recognize SFE 6?
Yes, I do.
And can you tell us what that is, please?
Sure. It's a breakdown of the number of customers that successfully signed the contract but failed the eTPV or TPV and were not enrolled. That's on point 1. So it shows a total from January of 2020 through to the end of September 2022, a total of 11,140. Then point 2 is the number of potential SFE customers that successfully signed a contract, completed the eTPV, but failed the QA call and were not enrolled as well. Same stats from January of 2021 till the end of September 2022, and a total of 4,460. The third bullet point, which is actually step 4 in the enrollment process that I talked about earlier, where our operational team does the back-end check with the utility on the EDI transaction to confirm the account holder record, so that since inception of that, the number of customer enrollments that were canceled because the account holder record did not match the individual who signed the contract and attest to be the account holder record was 26.
So is it your understanding that based on these numbers, there were almost 15,600 customers that could not get through the enrollment process and therefore their enrollments were declined?
That's correct.
And what does that indicate to you?
Well, from my experience, it's just a situation. The protections are there to ensure the customer understands what they're enrolling and getting into. We don't, as a company and organization, like to stick with the minimal requirements. We feel that consumer protection is of the utmost importance, and putting a customer through this level of rigor in order to confirm that they wish to proceed with a contract is important to us, not just to protect the customer, but also to protect, quite frankly, the company, and to ensure that we're only obtaining quality customers that fully understand the product offering and what they're signing up for. Majority of these cancellations could be a result of language barrier. Oh, customers made a decision, and now I don't want to go any further. So they made it through step 1, step 2. They may have opened up the email before the QA call comes. And I might add that that's also confirmed on the ETPV and the QA call that the customers received the email and has a copy of the executed contract and a copy of the contract summary. So it could be a various of those situations where they've just made a decision, no, fine, right? So the sales rep could have maybe caught them off guard. They may have been fine with what the original presentation was, and then they said, oh, no, forget it. I don't want to proceed. So they got several steps within the enrollment process to make that decision, and that's what this represents.
Your Honor, I'd ask that this one-page document be marked as SFE 7.
So marked.
Mr. Donnelly, has SFE made changes to its contracts and contracting process over the course of the last few years?
Yes, we have.
And are those changes described in SFE 7?
They are.
And can you point to any of these that are where the company changed the questions in the ETPV or the QA call, or in order to ensure that there were no misrepresentations or that the customer was fully knowledgeable about what they were signing up for?
Excuse me, yes. February 7th of 2021 is when we made some changes to the ETPV and QA script to require the customer to read back the business card that was provided to them that states SFE is not the utility, and for them to confirm their understanding that savings are not guaranteed. January 11th, 2022 is the changes to the I-sign process to only allow the account holder of record, including the back-end checks, specifically on the ETPV was revised as well on March 29th of 2021, where we required the following statement. You understand that SFE Energy is not the utility, the Maryland Public Service Commission, or the government, and the representative explained this first when they arrived at your door. That requires an affirmative response. If we do not receive an affirmative response, the contract enrollment's canceled.
And on March 29th, 2021, was that also added to the QA script as well?
Yes, I believe so.
Okay, so it says on the document that it was revised the ETPV. That should also say the QA script.
Yes.
Okay. So the I-sign, what's been marked as SFE 5, that has evolved based on SFE 7 since whatever changes are in SFE 7 were built into here, right?
Yes, as far as the textual changes, whether that be through the terms and conditions or the representations, we made sure that those changes happened in all of these steps.
Has the company used the I-sign process for residential door-to-door enrollments since the beginning, since before January 1st, 2020?
Yes, it began in 2019.
Okay. Your Honor, I would ask that exhibits SFE 5, 6, and 7 be entered into the evidentiary record as SFE 5, 6, and 7.
So staff, our objection remains the same with as it relates to SFE Exhibit 5, as it's not dated, and I don't believe the the witness testified to the dates of when this this form was used.
Well, the witness just testified that this form has been in use since 2019. Is that correct?
That's correct.
Oh, all right. So I will rescind my objection.
Okay. Any objection, Mr. Davis, to SFE 5, 6, or 7 being entered?
6 and 7 have been already been reviewed, and we have no objection.
Okay. Seeing no objection, SFE Exhibits 5, 6, and 7 are moved into evidence.
So can you pick up SFE 7, please?
Just remind me again which one I should have been marking to myself when we were going along.
SFE's changes to its contracts and processes.
Yes.
Are there, I want to talk about the contracting issues. Are there entries in this chart that reflect SFE's changes to its contracts after Statewise came out? The order came out? Or before the order came out?
Yeah, we were always evolving and making changes based on CAD decisions, and in order to continually improve the consumer interaction process and consumer protection. So in November of 2020, at the top of the list, we made the change to separate the contract summary from the single PDF that the customer received in the welcome email. So back to what I was explaining before, what the email looked like, and there was two PDFs. One PDF contained the contract summary or summaries, depending if the customer signed gas and or electricity. And the second PDF was the completed contract with the welcome letter as the first page, and then the contract agreement and terms and signature at the end. We separated that out into two PDFs in November of 2020 because it appeared that there was some confusion with CAD and our responses about them taking the position that they formed, the contract summary was forming the contract, when that was not our intent. So we felt that separating them out into two PDFs would make it very clear and transparent that they were not part of the contract.
Okay, so has SFE been able to revise its contracting documents in an effort to comply with what was in the statewide proposed order?
Yes. So, for example, if you look at in February 2022, again, our position on this was just more of a situation of not having a full understanding of the contracting process flow. So we moved the signature block that the customer signs actually on the device that then generates the PDF. We moved that to the end of the contract terms because there was a misconception that that somehow was a standalone signature page, even though it was still part of the one PDF that was being provided to the customer containing the contract terms and the agreement. Then in April, specifically April 6, 2022, we added page numbering to the entire contract package. So similar to what was reviewed earlier today, the page numbering was added to the entire agreement and terms and signature page, including the cancellation provisions and the copy of the business card from the sales representative. But I think I got one step back. Let's see. So so sorry about that. It was in November, end of November 2021. We recognized during the process of the statewide settlement that we made additional changes to the contract summary to import dates and utility names onto the cancellation form that was already being provided to the customer with two copies. We made that change prior to the order being released.
So just to clarify, SFE was always giving customers two copies of the notice of cancellation, but now it completes the form for the customer, so it has the customer's name and the dates, today's date and the date the rescission would be due? Is that
Correct.
Okay. And were some of these changes made, did you have discussions or communications with staff, with CAD?
Yeah, we made attempts to have discussions with CAD on the changes that we were making.
Okay, and were you continuing to get some results that were in the customer's favor based on the contract issue?
Yes, we were. Even after making these changes in 2022, we were still receiving decisions in the customer's favor in relation to the contract formation issue.
Your Honor, I'd ask that the document, that the cover page with the email that was sent on Wednesday, July 20th, 2022, be marked for identification as SFE 8.
So marked SFE 8.
Mr. Donnelly, can you,
This
Tell-
is public?
this is public, yes, thank you. Can you tell, no, it's not, I'm sorry. It's got, the attachment is a CAD complaint decision. So,
Confidential?
I think in the subject line mentions the name and the address, so it has to be confidential.
So this is SFE 8C.
Yes. Thank you, Jake.
Yeah.
Mr. Donnelly, can you tell me what this communication is?
Yes, this is an email that my manager of compliance, Elgin Tagle, had sent with my direction to CAD, just asking for some clarification. Because we received a decision not in SFE's favor that was specifically just in relation to the contract formation. But we also had another decision for the exact same contract formation with Statewise that was deemed to be compliant. So we were asking for clarification from staff because we had conflicting CAD decisions. And at this point, juncture in the process, we were perplexed as to why one decision with the exact same contract formation was considered compliant and another one was not.
And have you since received decisions from CAD valid, or I guess ruling that enrollments are valid under the new and improved contract?
Yes.
Can I give you these? Torres and, yeah.
Yeah.
I was wondering why they didn't have copies. Your Honor, I'd ask that the document that is complaint number 036960 be marked for identification as SFE 9C,
So marked.
and the document or the complaint number 036860 be marked for identification as SFE 10C.
So marked.
Staff has an objection to 9C. Based on that this is outside the review period, it says on the last paragraph, SFE confirmed receiving your complaint with the PSC on September 30th, 2022. The review period was for resolved complaints by September 30th, 2022.
Mr. Green?
Your Honor, this is to show that CAD has ruled that the contracts are now valid and the issue is behind us. One of the, under 7-507, the good faith efforts to comply and so forth, the company has been working diligently to try to get the contract to the point where CAD says it's okay, and they've gotten there, they believe, with these two. There is one residential and one commercial.
Well,
I think-
staff witness in his last testimony recognized the good faith efforts of SFE. This is outside of the scope. So you haven't moved it yet, but I suspect Mr. Davis will object when you attempt to. 9C.
I
You're trying to,
respectfully, it can't be outside of the scope because the complaint period ended, but the company was still making efforts to comply with the CAD decisions that were coming in fast and furious throughout 2022. So the company continued those efforts as indicated in SFE 7 into 2022, 2023. Now we're very happy that we finally think we've made it, and I think the commission would benefit from that information in this case if there's going to be a penalty involved.
well, that's yet to be determined, but the complaint period ended here September 30, 2022, and to the extent that the company has made strides to become even more compliant than it argues it would, that could be addressed at a later stage. But if Mr. Green, you're just trying to show that the commission that the processes have continued to evolve and the company continues to improve its compliance practices, I think you can get that through your witness here without having to actually submit a letter from this commission's CAD division outside of the complaint period.
Mr. Donnelly, is the company has continued to reform and revise its contracts to satisfy CAD, correct?
That's correct.
And do you have any reason to believe that the company might have already accomplished that goal?
Yes,
Why?
because of the recent CAD decisions after we made all the changes on or around the time of the statewide order.
You have received CAD decisions after the complaint period that ruled that the contract in question was valid.
That's correct.
Okay. And those customers signed up using the new changes to the contract.
That's correct.
Okay. All right. Thank you. So let me touch on the staff do you recall that staff had some testimony in its written testimony and this morning live about one drop request that allegedly was not handled timely by the company?
That's correct.
Okay. And do you believe that that's an isolated incident, or do you believe that's some kind of pattern of some bigger problem?
It's actually most definitely an isolated incident. What specifically happened in that case was the customer had not been, the enrollment hadn't been accepted by the utility by the time the customer called in to cancel, and the customer service representative in error clicked cancel request. But if you're familiar with the EDI transactional process, if it hasn't actually been accepted by the utility yet, you're supposed to submit a request to rescind it. It's a different EDI transactional number. Is simply just a human error that resulted in it. So what happened was the enrollment still happened, and then the cancellation was dropped afterwards. It was still processed within the correct time period. It's just because it should have been submitted by our operational team as a rescission rather than a cancellation request because it wasn't enrolled yet, technically.
Does the company have a process for its customer service reps to handle drop requests received from customers?
Yes, they do.
Can you tell us what that is?
Sure. Inbound call from a customer, request to cancel the contract. Customer service rep will remind them of their contractual obligations, specifically the cancellation fees. In majority of cases, if the customer puts up a fuss about the cancellation fees, we waive the cancellation fees. Customer service rep processes the drop. It's a simple process in our database. In selecting cancel request, it pushes a work manager to the operational team responsible for doing the transactions with our EDI provider and the utility, and then they send off the report through the EDI provider. It then gets transmitted to the utility, and the drops happen.
Do you believe that SFE has a history of adhering to that policy, its agents?
Yes.
For planning purposes, we'll plan to go till about 4:30 this afternoon. If we go 1 minute beyond 4:30, we'll reconvene tomorrow.
Your Honor, I'd ask that this one-page drops processed by SFE since 2019 be marked as SFE 11?
SFE 11, correct.
Mr. Donnelly, have you seen this table in SFE 11 before?
Yes.
Tell us what it is, please.
These are just the cancellation drops processed since 2019.
So this
Month
reflects,
over month, sorry.
On a monthly basis, how many customers call in and say, I want out?
Well, yes and no. It's the amount of drops that we process. Yeah, whether it be the customer, majority of times the customer inbound call request. It could have came from a customer email as well too. So
Okay.
Yeah.
But in a typical switch, where if a customer is switching from SFE to another supplier or back to SOS or sales service, that's not going to show up here, right?
no, it will not.
In fact, when would the supplier find out that that had happened in normal operations?
So whether it's just switching to another supplier or they had contacted the utility and request the drop, that'll come through in the EDI transactional notice.
Okay, so nothing, SFE would just find out about that after the fact?
Correct.
Okay. Your Honor, I'd ask that SFE 8C and SFE 11 be entered into the record. So you were in the hearing room this morning, Mr. Donnelly, and heard Mr. Herbert testify.
Yes, I did.
Do you have a response to his testimony finding a pattern and practice of deceptive marketing practices?
Yes, I do.
Let's hear it.
Sure. Obviously, from my experience, especially throughout my career handling consumer complaints for regulators, the determination about whether there's a pattern or practice comes from the disposition of the complaint from the staff reviewing and investigating it at the commission level or regulator level. In our particular case, in this matter, we've got 15 complaints over a 33-month period that were identified by CAD staff through their investigation to be valid. My respectful opinion from my experience, 15 complaints over a 33-month period is far from identifying a material pattern and issue with a particular licensee.
So if you have what's been entered as SFE 3, customer accounts opened January 1, 2020. You have it? Yes.
Okay.
So these are all the customers that enrolled during the complaint period, correct?
That's correct.
So there's almost 47,000 customers that enrolled,
That's correct.
and there's been 15 complaints filed. 15 complaints found against the company for misrepresentations.
That's correct.
Okay, and it is also your understanding from this morning that there are 26 that were CAD found in favor of the company?
That's correct.
Okay, and do you have an understanding as to why CAD found in favor of the company on those 26?
Yeah, I do. They found in favor of the company because of the contractual process, not just the signed contract, but the TPV and the QA with the contents and the requirements for the affirmative response from the customers, specifically that the sales rep did not make representations about being from the utility or the Public Service Commission or any other supplier, and also confirmation that the sales rep provided a business card and requiring him to read back the business card. All those elements resulted in CAD decisions in our favor, that they could not drive to the position that the customer's allegations were valid.
Okay. And do you have an opinion as to whether there was a pattern in practice of SFE enrolling non-account holders or unauthorized enrollees?
No, we had always required that the individual attest that they're authorized to enter into the agreement. It wasn't until during the process with the statewide settlement that we made additional changes to do a back-end check to verify. So previously we were relying on the customer's attestation that they were authorized to enroll the account, both on the contractual information as well as on the ETPV and the subsequent QA. That was determined not to be sufficient enough in our settlement discussions in relation to statewise, so we added the additional step on the back end of checking the EDI transactional record.
And the same question for commercial accounts. Can you talk about what the company does to ensure that the commercial account is being enrolled by someone who has authority to enroll the account?
Sure. Well, first off, we're only ensuring that we're using licensed brokers to conduct those commercial sales on our behalf. So these individuals and entities are already licensed by the Commission to conduct those services. We require not only the contract to be executed, the contractual provisions, and this is referring to an in-person sales, just so I'm clear, that the individual executing the signature line is attesting that they have authorization to do so on behalf of the commercial entity. If it is a telemarketing call to a commercial entity, the individual goes through a an automated verification call, whereby they have to attest through that process again that they have authorization to execute the contract on the company's behalf. We as an organization go one step further, and we actually have a policy that restricts certain titles based on the type of organization from allowing it to proceed even if the individual said that they were authorized. So I'll give you a typical example. We get small law firms signing up all the time, right? And our requirement is it's got to be a managing director or a managing partner that's signing that contract. So regardless if the individual attests to having authorization, if it doesn't meet one of those titles, it doesn't get processed. We have similar provisions for different types of organizations. We've developed this over the years based on our experience and on the premise of what would a reasonable individual assume when they review that contract based on the title of the individual on it, whether they have authorization or not.
Thank you, Mr. Donnelly. The last line of questioning is on the contracting issue. Do you have an opinion as to whether there is a pattern of providing inadequate information to customers?
No. In my opinion, it's just simply a matter of potentially misunderstanding or confusion by the parties reviewing the materials and misconception of what's actually happening.
And when did SFE become aware that CAD had a problem with the documents?
It may have been I know for sure in 2022, majority of 2022. Up until that point, we were receiving decisions from CAD in favor of the contract formation and the ETPV and QA process.
Okay. So, all right. That's all the questions I have, Your Honor. Witnesses available for cross.
Thank you, Mr. Green. Staff counsel.
Are you familiar with Mr. Herbert's direct testimony?
From this morning?
Correct, and the filed testimony that was filed on Friday.
Yes, I am.
So are you aware that there were 46 unique complaints that were evaluated through his testimony?
Yes, but I'm also aware there's only 15 that were determined to be valid.
I believe that's a misstatement of Mr. Herbert's testimony. Mr. Herbert's testimony can I read the? Yes.
Oh, thank you.
Page 4, starting with line 1 going to line, line 4. It says, I discovered that
So
46...
you're going to have to provide me with the exhibit. I don't have it.
I'm going to read it to you.
Okay.
I discovered that 46 of the complaints filed against SFE reference various claims of misrepresentation. Of the 46 complaints alleging supplier misrepresentation, 15 complaints are verified as being in favor of the customer by CAD and included in the staff complaint. Going forward to page 9. Page 9, line 17, footnote 7. There are 46 unique complaints in the staff complaint. Some complaints reveal more than one violation, so some complaints are referenced multiple times in the staff complaint, leading to the higher figure. Additionally, some complaints resolved favoring the customer from the review period of January 1 to September 30th, 2022 were not referenced in the staff complaint. And then moving forward to page 10, it specifically says on line 1, CAD found that 42 were invalid enrollments, and cites footnote 8, which references each complaint number. So are you aware that SFE had more than 15 complaints against it?
More than 15 complaints? Yes.
And are you aware that more than 15 of those complaints were resolved in favor of the customer?
That's not my understanding based on the evidence before us.
Is that your understanding based on what was just read to you?
I think that was exactly what you said on the first page that you read off. You said it was 15 that were valid.
So relating to the 42 invalid enrollments referenced on page 10, line 1, do you believe that, do you not believe that these are valid, or do you not believe that CAD made a finding of invalid enrollments in 42 complaints?
That's not what I'm saying. I'm saying the evidence by your staff is that there was 46 complaints and 15 were valid.
Right, I, again, believe you're misunderstanding. Going further, it says on page 10, line 8, it says, I found that 57% of the 46 complaints in the staff complaint were determined by CAD to be violations of COMAR 2053-0708 and 2059-0708. Does this lead you to believe that SFE had more than 15 complaints resolved against it?
No, it doesn't, because there is a big discrepancy in the staff report, including the amount of complaints that we have not received decisions on yet, and some of them are still under appeal.
Very well. So, in your role with SFE, do you oversee regulatory compliance for SFE Maryland?
Yes, that's correct.
And you are aware that SFE has a parent company, correct? SFE Maryland has a parent company.
Yes, that's correct.
Yeah, and what's the name of that parent company?
SFE Energy Inc.
And what's the name of the parent company for SFE Energy Inc.?
That would be our Canadian subsidiary.
Do you know the name of the company?
Yep, SFE Energy Canada Inc.
And then the parent for SFE Canada Inc., please?
Summit Energy Inc.
All right, thank you. So I have, in reply to, this might be confidential, so I will send this along. But in reply to DR staff data request 1-2, you provided information. You provided information on the enforcement actions against Summit Energy and all of its subsidiaries. I'd like to may I approach?
Yes, please. Make sure the witness gets a copy as well. Oh, do you have? No, you don't have a copy. 1 for the court reporter, 1 for the executive secretary, 4 for the commissioners, and 1 for the witness. Okay, we could share. Oh, one second.
And the font is small.
Yeah.
I sincerely.
Oh,
I might need a magnifying glass, Your Honor.
okay. Mr. Davis. Oh, we have an extra copy. This is, how are we marking this?
I believe this is staff exhibit 2, but C, depending on whether or not.
This is not confidential. These are public cases.
All right, document is marked as staff exhibit 2. What are we looking at, Mr. Davis?
So in front of you is a reply to staff data request 1-2, where SFE provided information on prior enforcement actions that are against Summit Energy and all of its subsidiaries, including those in Canada and the United States.
Thank you. Questions?
Yeah, so I would just like to confirm that the commissions in Maryland, Ohio, Massachusetts, Pennsylvania, New York, and the Canadian states of British Columbia and Ontario have filed enforcement actions against SFE's parent company, Summit Energy, and SFE affiliates. Is that correct?
Yeah, that's correct. Majority of these are over 10 years old.
And these enforcement actions, for the most part, are related to customer enrollments, contract materials, and marketing materials. Is this correct?
I wouldn't go as far to say that.
Is it correct to say that the enforcement actions were based on the activities of SFE and its business operation, or Summit Energy and affiliates' business operations in each of the aforementioned jurisdictions?
You're asking me to look at a summary that I can barely read, that is essentially a summary for disclosure purposes.
This was provided by you.
Yeah, but problem is I can't read the text.
This was a data request from staff data request 1-2.
No, I understand that. You're asking me to verify, but I'm having a difficult time reading the summaries.
Mr. Davis, was this document prepared under the direction of or by somebody at SFE? Or was
Yes,
this?
it was provided in response to staff data request 1, which requested information regarding SFE's parent company and affiliates.
Okay.
Well, I
Mr.
think
Donnelly, would you stipulate to the authenticity? It appears that this is a document created by SFE that was tendered in response to a data request.
yes, Your Honor, I'm not disputing that. I think the easy answer to the question is that some of these will be as a result of marketing activities, and some of them aren't.
Right, thank you. So then, moving forward, with so in data request 2-4, which was also marked as confidential. Mr. Green?
Feel free to use your co-counsel, Mr. Wilson, to help you. You have extra hands here.
Thank you. Oh, that's perfect. Thank you.
So I'd like to direct your attention to the back of the page, which identifies the training materials, or the training schedule that was used that was provided in reply to staff data request 2-4. Are you familiar with this, with those training dates?
Are you referring to paragraph D?
Correct.
Okay, yes.
And I believe a lot of these dates correspond with SFE Exhibit 7. Can you verify that the implementation date for some of these changes in Exhibit 7 corresponds?
Sorry, can you do me a favor, just show me what Exhibit 7 was,
Yeah.
because I wasn't marking them on my end, so.
Changes to SFE changes to contracts and processes.
Yes, I have it.
So this includes, the document that's in front of you includes 1 field observation and 2 trainings spanning the review period of January 1, 2020 to 9/30/2022. Is this correct?
That's correct.
Is this the typical frequency of trainings for SFE?
No, and just to clarify, these are group training sessions, not individuals, so this doesn't represent any compliance action that we took on individual sales representatives. That was all previously disclosed with as part of the process, the disclosure process. Sorry. This does not represent the typical process. Keep in mind that we're talking about a review period that also still had the remnants and after effects of COVID. So there was travel restrictions. Our field compliance staff member travels and works out of home office, but he is in New York. So this would be a reflection of the fact that we had remnants of COVID restrictions still during periods of this time lot that you've identified.
So going further, do you, are these, so in your experience then, are the amount of people that were at each training, in terms of fluctuations between them, is this standard with the industry, or were there more, was there a higher number of people at the COVID restricted trainings?
So I'm not quite understanding what you're asking.
I'm asking, so in reference to the amount of people that attended each training,
Right.
do you normally see fluctuations like you've provided in your response?
So the amount of people at the training is irrelevant because it's depending on how many active sales reps were available at that given time.
So in each specific training, you trained every available sales rep.
That's correct.
So are you aware that SFE received 136 complaints during the time period that you only had 2 trainings?
Yeah, I'm aware. I'm also aware they weren't all valid.
Okay. Yeah, I have no further questions.
Just so I'm clear, was that last exhibit marked?
I'm sorry.
No, it was not marked.
That would be staff exhibit 3.
And is it confidential?
Your Honor, the only confidential
I think the front.
is in C. It mentions the agent's names.
Okay.
I think the rest is public, or can be public.
So I'm just asking how I should mark it. Should it be 3?
We can just do it confidential.
Okay.
Yeah.
3C. All right.
So it's staff exhibit 3C, confidential.
Oh, there's been no request made of the bench yet.
Yeah, I'm about to. I would
Okay.
like to move in staff exhibit 2 and staff exhibit 3C.
Well, we haven't marked 3 yet. You're making a request to mark 3?
Oh, I'm sorry. Yes, I would like to make requests to mark 3C.
3 so marked.
And I would like to move staff exhibit 2 and staff exhibit 3C into the record.
Object to the admission of staff exhibit 2 in terms of relevancy. There's the code looks at, for 7507 purposes, what's relevant in Maryland and infractions that may have occurred in the state. And it's to infer, as staff seems to want to be doing, that some sort of case from 2008 or 2000, somewhere else in a long time ago or other places without more should be relevant here is objectionable. It's similar to the criminal issue where you say he did this crime over there, so therefore he must have done it here. And to the extent that these are even violations, because some are settlements and some are other verdicts, but it's just not relevant, and he didn't explore it at all in depth to make it relevant.
Mr. Davis.
I believe this is relevant in the fact that SFE has continually brought in their relation to statewide throughout this proceeding in both written testimony and here in the hearing, as well as this sheet of enforcement actions or liabilities investigations includes information from Maryland and within the review period.
Well, there's only one Maryland line item, I believe. Is that right?
You're correct.
And that was a settlement. Should we?
It's a public. It was a civil penalty, and there's a public. There's public record of the proceeding.
There's public record of the proceeding. I think the fact that there was a penalty assessed carries more weight. I'm looking at 7507 right now. Mr. Green states that the law does not allow us to weigh actions outside of this jurisdiction. How do you respond to that? Because this is quite an impressive list. Although, as Mr. Donnelly stated, this goes back,
I think to 2008. Yeah.
2008.
8, I believe. Or 13.
All right, so how do you feel on the jurisdiction?
I believe it's relevant to the extent that SFE has referenced throughout this proceeding that that its affiliates and its parent companies dictate how it operates its business processes.
Mr. Green, where explicitly in the statute does it say that the commission cannot look at regulatory actions taken outside of the state of Maryland?
My recollection was that it spoke to actions by the commission or actions taken by the company in response to prior violations, and it was limited. It spoke to commissions, and I may be wrong, but that's the way I've always looked at it. The other problem with this is that you're talking about, until we get to page 2, we're talking about actions that were started 10 or more years ago, and you've got 3 that involve SFE Energy Maryland. Actually, 2, because I believe the others are statewide. So,
SFE Energy Maryland?
I'm
Or just
sorry.
SFE Energy?
SFE Energy, my fault.
All right.
I just don't. Some of these aren't even in this country. I just don't. We don't know what the without knowing more about what went on and who was responsible. I mean, I don't. We don't even know if the same people are around. We don't know if the same leadership is around. We don't know what the issues were in those cases. We don't know if they have any relevance at all to the issues in this case.
Mr. Davis, anything further?
Yeah, I would say that when you look at I'm sorry, hold on. Yeah, 7507 K 3 little number X or Roman 10, suspension or revocation of a license by any state or federal authority may be considered under the just cause requirement for the revocation or suspension of a license.
Yes, little Roman X does seem to allow the commission to consider those actions. All of the actions listed on Staff Exhibit 2 that occurred in the United States are in. The Canadian ones are out. Staff 2 and Staff 3C are moved into evidence. All right, Mr. Auslander.
Thank you, Mr. Chairman. Good afternoon, Mr. Donnelly. How are you?
I'm doing fine. How are you?
I'm good.
Mr. Auslander, sorry to interrupt. I'm just trying to plan the day, get us out of here by 5 so people don't miss their trains.
Sure.
Approximately how much crust do you have?
I'm really bad at estimating this. So I'm going to try to get through it as quickly as possible. I don't think I'm going to jeopardize people's train rides home.
Okay, well, obviously the commissioners may have questions, and then we will deliberate. We'll likely return a verdict hopefully today, maybe tomorrow. We'll see, but I don't mean to rush you.
Sure.
So proceed.
Thank you. Mr. Donnelly, can you repeat your job title for me one more time?
Vice President of Regulatory Affairs and Compliance.
And then I think that you mentioned that you are employed by SFE Energy. Do you also work for Statewise? Or if not, explain that relationship for me.
It might be beneficial if I explain the corporate org structure so you have an understanding. So the management service entity that relies in Canada is responsible for all the back-end operations compliance processes. They have a management agreement with each of the entities in the U.S. to provide those services, and then we outsource the sales services using vendors under contract.
Okay, and so I'm not sure that actually answered my question. What can you explain what role you play in the entity known as Statewise?
I'm still responsible for all the same aspects of regulatory affairs, legal, and compliance.
Okay, and if I recall correctly, you actually filed testimony on behalf of Statewise in the previous enforcement action against Statewise.
That's correct.
Okay. I think when you were answering questions from Mr. Green, you stated that SFE did not ramp up its enrollments following the enforcement action against Statewise. Is that correct?
That's correct.
But is it also true that Statewise has not engaged in actively marketing residential customers since that PLJ's order came out in that case?
Yes, and I'm happy to explain why.
Okay, sure.
Sure. Statewise is a partnership. It's an LLP. We had a partner that was majority owner, 49%. We were in the process of buying that partner out. That partner was responsible for the complete sales arm of the organization. So by virtue of being in the process to buy the partner out, we weren't continuing with sales because you never come to determination on the valuation of the business if you continue adding customers into perpetuity. So we had made the decision to stop sales in order to negotiate that process of buying out the partner, and that's basically it.
Okay, so just to clarify for what I'm interested in, you didn't ramp up. You're claiming that you didn't ramp up with SFE, but you did not actively engage in any marketing on behalf of Statewise after the POLJ's order came out.
That's correct, because we also didn't submit the compliance plan yet.
That's right. All right. I know that you didn't submit any written testimony in this case. That your testimony today is what you're presenting. But did you have an opportunity to read the answer that SFE has filed in this case?
Yes, I have.
Okay, and I'm just gonna read you a sentence from that answer. It's on page 18. It says, "Statewise was not an island entire of itself, and the measures imposed upon it by the settlement to ensure compliance were de facto imposed upon and adopted by SFE." And I think that what you're saying here in the answer is that that SFE voluntarily took on the obligations imposed on Statewise in the case against Statewise in case number 9661.
Yes, because that was the prudent thing to do.
Okay. Now, one of the exhibits that you had attached to SFE's answer was a copy of the POLJ's decision in the case, and the POLJ did not simply adopt the settlement agreement wholesale, correct? She added some conditions.
That's correct.
Okay, one of the conditions that she added was that Statewise would be required to discontinue the use of the electronic verification ETPV process.
Yes, that's what it states.
Okay. And just so I'm clear, SFE has not discontinued the use of its ETPV process.
No, because our understanding from the settlement discussions and the evidence that was put forward was that It was an understanding that the eTPV process was being used as a standalone in order to enroll a customer on its own. That's from my experience and being in the process for the period during the settlement discussions. So,
All right, and I'm going to turn your attention to what has been marked as SFE Exhibit 5. And I know that you said that you were
Yeah,
marking it.
which one is
It's
it?
the I sign, touchless
Yeah,
sign. And if you turn to page 9, if you could turn to page 9 of 17 for me. And there's a, yeah, that's the one. So there's a box here, and can you confirm that this is what the customer would be looking at, and then they're going to sign their name electronically? That's what that squiggle is at the bottom.
excuse me. Yes, what I testified earlier this afternoon is that the customer has to scroll through the entire box, reading the entire terms and conditions before they're able to agree and sign. This particular screenshot already shows the end of the terms and conditions.
Yes. And would you agree that, or could you point me to where there is a notice of the customer's right to rescind the agreement near their signature here?
It's not in this body here before the signature, but it's contained in the terms that they scroll through.
Okay, so it's not, just to be clear, it is not near the signature on this document here.
Not on this example.
Okay. Earlier when Mr. Herbert was going through his testimony, Mr. Green entered some documents into the record, and I want to enter some of my own at this time.
Thank you.
Your Honor, if I could get this marked as OPC Exhibit 1C.
So marked.
And this is the, just for background information, this is the contract documents associated with CAD complaint number 000355374, which is the CAD complaint number that Mr. Herbert references in his testimony on page 11 at lines 7 through 14. And if you could turn to turn to page 4 for me. It looks like that. And if you could look down at the signature, do you see a signature on this page here?
Yes.
And do you see a statement informing the customer about their right of rescission near this signature?
No, in this particular complaint, we identified the IT error. It wasn't being populated into the contract, and it was immediately fixed.
Okay. Is it possible that this error affected other enrollments?
It affected a subset of enrollments that was reported, I believe, with the complaint information. So.
And is that true also then of the of what the customer sees on SFE Exhibit 5, where they're signing a document, but there's no notice of the customer's right of rescission near the signature?
You're referring to the sample?
Yeah.
Yeah, the right of rescission isn't appearing right by the customer signature, but as stated before, it's in the scrolling portion.
Okay, thank you. All right, now I think earlier you mentioned that SFE has enrolled 29,000 residential customers.
No, that's our current count.
Oh, that's your current count. Okay, so the actual number is actually much higher than that.
Yes.
Would you hazard a guess?
I think we said earlier is close to 47,000.
47,000,
Yeah.
and that was for that period between 2019 and 2020.
Yes, I believe so.
It's Exhibit B or Exhibit 3.
Yeah, Exhibit 3. Great. Okay, and of your current 29,000 residential customers, I think you estimated, or maybe you confirmed Mr. Green's estimate that about 25,000 of them were enrolled in door-to-door sales.
I believe that's what was said earlier.
Okay, and in a door-to-door sale, that meant that there was essentially 25,000 sales agent interactions with each of those customers.
No.
Okay, so maybe explain to me how you could have 25,000 door-to-door sales and not have 25,000 door-to-door sales agent interactions.
Because what you're looking at is actual enrollment counts. You're not looking at sales interactions. So sales interactions is way higher than the total amount that actually get enrolled. If you consider the amount of times the sales rep knocks on a door, maybe they get 1 out of 10 customers if they're lucky. So if you want to talk about solicitation interactions, we're maybe 100 times.
Yeah, so I said, and let me rephrase. So there were at least 25,000 sales interactions, but I think what you're saying is that the true number is actually much higher because not every sales interaction actually leads to a sale.
Correct.
Okay.
Correct.
And I think you also mentioned that SFE uses vendors to conduct these door-to-door sales. Is that correct?
That's correct.
And I think you also said that you only use one door-to-door vendor?
Presently,
And what's the name of that vendor?
iMarket Global.
iMarket Global. In discovery in this case, OPC had requested information about the sales agents that SFE uses. Do you recall those data requests?
Yes.
And one of your responses that I've not reproduced here because it is a 353-page document, you list a number of sales agents, the name of the company that they work for, and where the door-to-door sale occurred. Do you recall that document? It was the SFE's response to OPC data request 1-7?
I'm aware of the disclosure.
Okay. Now, OPC had also asked for SFE to provide documentation that each of those vendors' agents had the peddler's license that is required by the local jurisdiction where the sale occurred. Do you recall that question?
Yes, I do.
And what was SFE's response to that, to OPC's data request?
I believe our response is that it's the indemnification and obligations are within the vendor agreement with the vendor. Because we don't employ the vendor, we don't employ the sales representatives, the obligation's on them to obtain the permits. We can't obtain the permits for them because they're not our legal entity. And depending on the county and jurisdiction, the permit requirements is either held by the corporation or the business entity themselves, or it's held by the individual. So both in the vendor agreement and as well as the agent ICAs, independent contractor arrangements, they have to attest that they're going to comply with all those local ordinances.
Okay, so if I'm correct, then SFE ensures compliance by just having an agreement with the vendor for the vendor to ensure compliance. Is that fair to say?
That's fair to say, and I don't recall actually receiving any complaints in relation to that issue.
Okay. With, I think you mentioned some difficulty or some limitations that you have or that SFE would face in getting the permits or the peddler's licenses themselves. So would you agree that SFE completely relies on their vendor to carry out their obligations to ensure that their agents meet the local licensing, registration, and permitting requirements?
Yes, and I'm not aware of any complaints on that nature that would cause an alarm for us to take any further steps.
Okay, other than the allegations of misrepresentations by door-to-door sales agents.
I don't think that's related to obtaining a solicitation permit.
So you don't think that being licensed to engage in a business activity might affect the door-to-door sales agents' performance of those duties?
No, because we're talking about the misrepresentation at the solicitation at the door about our product offering and who they're representing.
Okay. One second. I don't have anything else. Do you have anything else? I don't think I have any more questions, Your Honor. Thank you.
Thank you. Mr. Green, any redirect? Then the commissioners will ask questions. And then parties will have an opportunity to ask questions based on the commissioners' questions.
Yes, I have a few questions. Mr. Donnelly, looking at what's been entered as staff 2, the chart about other enforcement actions, and
Excuse me. Yes.
it's the chairman limited it to the American, the states where there have been actions, but I'm curious, how many customers are in the SFE family footprint across America, if you know? Can you ballpark that for us?
I'll ballpark it by stating that it's in excess of 400,000. I'm trying to be cautious about divulging our customer
My
counts,
fault, yeah.
not under confidential disclosure. So,
Mr. Auslander asked you some questions about the notice of cancellation and the I-sign.
yes,
Is the current contract that SFE is now using as of, before I ask that question, can you turn to the document that has the contract changes on it? It's SFE 7, but it's this big table. When did SFE incorporate the notice of cancellation in immediate proximity to the signature line?
oh, it was done immediately after identifying the error when we received the CAD complaint on that one contract.
Right. So according to the table here, is that November 26, 2021?
Yes, that's correct.
Okay. And if you go back to the contract that Mr. Auslander gave you, what is the enrollment date of that contract, of that customer?
So bear with me. October.
Year?
2020.
Okay. So to the extent that subset of customers in the IT problem occurred, that's been resolved by the company and certainly was resolved by November of 21 at the latest, correct?
Correct.
And so going back now to the I-sign example, going back to page 9 where you were with Mr. Auslander,
Yes.
in the current iteration of the contract, does the notice of cancellation appear in close proximity to the signature?
Yes, it does.
Okay. And that it would be as of November of 2021, right?
Correct.
All right. At least for,
Subset of customers.
Right.
Yeah.
okay. Your Honor, that's all the redirect I have.
Thank you. We'll have an opportunity for commissioners to ask questions at this point. We'll begin with Commissioner Bubar.
Thank you. Thank you, Mr. Donnelly. I noticed you're left-handed. There's so few of us that are left-handed in this room, so.
The watch, right?
Can you just describe what is the product that SFE sells And what I'd also like to understand is, it seems as if there's some tiers maybe that customers might enter into. And I wanted to understand if my understanding is correct, but also how do you ensure that your representatives who are going door to door understand that to be able to explain that to the customer?
Okay, so there's two product types. There's the fixed commodity product offering, fixed rate, fixed term, and what I believe you're referring to is the daily flat rate fixed term. The daily flat rate product offering is a set amount daily, which is capped based on the customer's usage. So, for example, with electricity, it's 15,000 kilowatts annually. So, how we apply that program with the disclosures with the customer as well, both in the contract and in the TPV processing, is we advise them that this is the product they're selecting. It's capped at 15,000. If they use more than 15,000, there'll be an overage charge of a fixed rate that will be applied. So what happens is then when we receive the contract and we get the historical usage from the utility, we examine the usage amount. In almost all cases, the customer continues on at that rate, meaning if they signed up for $2 a day, for example, they get $2 a day for the year. And then on an annual basis, which is in the contractual terms for that specific product, is we'll reevaluate the usage for the annual period. If they still remain within the 15,000, they continue on at the $2 a day price, for example. If they go over the 15,000, so say they're at 16,000, for example, in fact, our thresholds actually push it further. We have some leeway where we allow the customer actually to go, I believe, to about 17.5 before we actually apply the overage, even though the contract says 15,000. They'll apply that fixed rate that's been disclosed in the initial sign up to that difference, right? So say, for instance, I'm not great with math, but for argument's sake, let's say it's 18,000 they have in year 2. They'll end up being charged, say, $2 and maybe 28 cents a day to cover that extra overage for that year. And then if they sign a contract, say that's for 3 years, we'll do that same exercise at the end of each calendar year from the time they were enrolled until they get to a full 365 days in the year. And we'll do that same analysis.
And that's 15,000 kilowatt hours.
Correct, yeah.
So do your representatives have the ability to help a customer understand where they might be in that range?
Yeah.
Based on their behaviors?
Yeah, they do. I'm sure we're all familiar with electricity utility bills, for example. They usually have a table over on one side or at the bottom to tell you what your usage has been, month over month or year over year. So it's fairly easy to get a decent gauge. And in fact, that the iSign process is one thing I omitted. There's actually the ability to take a screenshot of the customer's utility bill so that we can have that information as well when we're doing that review process.
Okay, that's helpful. Thank you.
You're welcome.
I have a question on SFE 7, the table that we keep referring to. And there is a footnote that notes that a row was added from what was originally sent in SFE's response. And I just have a clarification. The row is for March 29th, 2021, when you revised the TPV. But it's out of order, so I just wanted to make sure, is it really 2021?
Yeah, that was just the mistake in putting it in order.
Okay.
The dates are correct.
Okay.
Sorry about that.
Oh, no problem. So because, another real question I had on this was, I wanted to really make sure I better understand, and I think maybe our staff was trying to get to this too. What is the training protocol and how often does that happen? Because this table has Q4 2022, you retrained agents and scheduled field shadowing to ensure compliance. So are agents trained regularly as they're hired, and then you do something in addition to that?
That's correct. That's correct. They're initially trained upon the onboarding. That's why they have to do the test. That's why the marking of the test and approval of the score is done by my compliance team. It's not done by the vendor. And then there's additional training done on a as-need basis. So, for example, when if we identify a specific trend that we're getting certain type of complaint coming from one vendor that's multiple sales reps. And unfortunately, in this circumstance, that's not the case. We only identified the trend with 2 sales reps in total for the entire time period. But for example, if we do identify a trend to say we're getting some misrep complaints, even if commission, for example, CAD is finding in our favor, But we still identify, well, wait a minute, like all these complaints are attributed to these 3 reps, and it's been going on for the last 4 months. Then we'll send our guy out, or we'll have our guy give a call, compliance member, give a call to the vendor. The vendor gets weekly and monthly reporting on complaint trends from our office as well too, and we do weekly and monthly calls with the vendor-specific vendor principal themselves. And then over and above that, we would do direct training with specific reps if we identify a specific issue that needs to be addressed.
Okay, thank you. I have one more question. The QA step that you mentioned in, I think, your 4-step process, is that an independent company that does that independent verification, or is that somebody in SFE who does that quality assurance step?
The QA portion is done in Canada at head office by staff that specifically just do that, the QA piece. Yeah.
SFE?
Yes.
Okay, that's all my questions. Thank you.
Thank you. Good afternoon, Mr. Donnelly. I have some questions starting with your independent sales representatives, which I think in some of your documentation are referred to as residential independent contractors. We've also heard the term agents used today. So contractors, agents, independent sales reps. Looking at SFE 4, it says they're part of the SFE family. Can you explain how they're part of the SFE family?
That's just really optics, Your Honor, to help sales reps, feel like they're going to be contributing to the sales process and the overall achievement and performance of both themselves and the parent company.
We spent a lot of time today talking about door-to-door sales. It's a relatively tough business. I think you would agree.
I would agree.
The agents you stated earlier are, quote, not the most sophisticated individuals, end quote. Can you explain that?
Well, I'm sure you can appreciate, Your Honor, depending on the type of industry and business an individual is in, they are opted for that business for whatever reason, whether it's a lifestyle, they prefer to work for themselves, or whether that's just the only job that they can get, for example. But, the reality is the door-to-door sales reps are not individuals such as myself or you that have a education and post-secondary education and prestigious background. They're individuals that are young. They're trying to struggle. They're trying to make a living. They're trying to make something for themselves. They can't get a job, working at a regular retail store. We all see what Maryland's like outside here right now in the downtown core, right? It's difficult for these young individuals to get jobs. So they're trying their best and they're going for whatever opportunity they have, and those are the type of individuals that we see that gravitate to this type of business, and it's because they need an opportunity, to be quite honest.
You mentioned education in your response just now. Is there any minimum educational requirement?
No, we don't, other than the training we provide that requires the testing and a minimum score of 80%.
In SFE Exhibit Number 4, there's a reference to a daily pay target. Does that reflect a commission-based compensation for these sales agents?
Which page, Your Honor? I'm sorry, they're not page numbered, but...
No. I saw something about unlimited earning potential.
Yes, that reference is because these representatives are paid on a commission basis.
They are, okay,
Yeah.
all right. I can't find the reference to a daily pay target, but I saw it in there somewhere. All right, so they are commission-based employees here. Are there financial penalties assessed on any of these sales agents if they're found to have committed numerous violations?
Most definitely. All of our vendor agreements have clawback provisions, depending on what's negotiated, but on average 30 to 60 days, let's call it. So if we receive a customer cancellation, drop, or consumer complaint that results in us having to cancel the contract, then whatever funds we pay to the vendor is clawed back, and the vendor would in turn claw back from the sales rep. We don't pay the sales representatives directly. Our agreement's with the vendor. The vendor's responsible for whatever their contractual arrangement is with the sales representatives. But in essence, the vendor claws back from the sales rep too if the sales rep's still active and selling on behalf of them with our product offering. So yeah, and complaint that results in cancellation, clawbacks. Compliance issues can result in penalties. For example, we have increments of penalties starting at $250 and going up to suspension and termination, right? We implement that. My compliance team enforces it with the vendor office, and even if we get in a dispute with the vendor about whether they agree with us or not, it really doesn't matter what their opinion is. We control the access to the whole platform on our own internal database. So click of one button to deactivate the sales rep. They can't make a sale to anybody.
I was not familiar with the vendor until you mentioned the name today, iMarket Global. Are they a Maryland-based company or are they a national chain?
National, Your Honor.
Are you familiar with, obviously we've been discussing your complaint record today. Are you familiar with SFE's current rating with the Better Business Bureau?
I'm not familiar with what the rating is presently.
Okay. Would you take administrative notice that's currently an F? Would that surprise you?
I don't think it would surprise me because I think everybody needs to have an understanding of how the Better Business Bureau actually operates, and specifically on what determines a rating. And simply responding to a complaint and taking a position that the customer's complaint isn't valid and providing those subsequent documentation to the Better Business Bureau, unfortunately doesn't result in you getting a good rating at all. The Better Business Bureau wants to see in almost every incident a refund given to the customer.
Would you consider yourself relatively sophisticated with the Commission's CAD complaint process?
I'm sophisticated with the process. I'm perplexed in some of the decisions.
You recognize that your customers first need to attempt to resolve the complaint with SFE prior to filing a complaint with the Commission?
I am aware, but from a practical perspective, Your Honor, the Commission's never pushing the customer back to us first before they take the complaint. We've never experienced that.
Are you stating that complaints filed with the Commission the customer has not first contacted SFE?
I would take an educated guess that maybe 20% have.
Assuming a Maryland customer that has an issue with the service that they're providing with SFE, in what percentage of cases do you believe those are resolved prior to coming to the Commission, if you could venture a guess?
I can't give you a specific number, Your Honor. That from a process perspective, the issue is that customers, they call in to cancel. We process cancellations. There's cancellation fees associated with the cancellation. What ends up happening is if we enforce cancellation fees with customers that have no complaint, Your Honor, they're just calling in to cancel because they feel that, the utility rate's better at this point. I don't want to continue with the contract. We enforce the cancellation provisions. A material amount of time that results in a complaint that gets either to the Better Business Bureau or to the Commission. So by virtue of process, what we've done over the years is we stop enforcing cancellation fees to try to reduce the number of complaints that are making its way to the Commission and the Better Business Bureau, because the customers are pushing the complaint forward only because they don't want to pay the cancellation fees. So we understand that's a cost of doing business. Further to that, I think it must be noted and emphasized that with every single CAD complaint, even the ones that are found in our favor, we're waiving cancellation fees. And all the ones that aren't in our favor have all been refunded.
You testified earlier it's typically your process. If the customer pushes back, you simply waive the cancellation fee.
Correct.
Looking at SFE 3, which is all of the accounts that were opened during the complaint period, which totaled almost 47,000. Currently, you stated you have 29,000 customers. Is that level of churn normal?
It's normal for the industry, Your Honor, for door-to-door sales. Yeah.
Do you ever enter into either non-disclosure agreements or confidential settlements with unhappy customers?
We enter into settlements and releases with unhappy customers, primarily on the commercial side of things, but not on a residential basis.
Have you ever entered into a residential confidential agreement to buy a customer's silence effectively?
Oh, no, not to buy a customer silence, Your Honor. Never.
But a confidential agreement would effectively contain a term that prevents the disclosure of that, the existence of that agreement, no?
Yes, but it's typical in legal practice. If the customer wants a refund and you want to be amenable to the refund, but you also want to protect your rights, that's fine. You don't want to deal with customers that you're giving a refund and fixing the issue to just turn around and deal with it all over again.
Okay, so there have been instances where SFE has executed a settlement to prevent the customer to...
I can't answer that for Maryland specific.
Okay.
I don't recall, to be honest with you, for Maryland specific.
If such a settlement or confidential agreement would be signed, who in the agency or the organization would sign that?
That would be me.
This question may raise an objection with your attorney, but I'll ask it and see if he objects.
Who would rule on that objection?
Commissioner Linton, actually, that's a good question. Has SFE ever appealed a CAD determination or requested further review?
Yes, many times.
We saw in SFE number 6 at the very bottom the new account holder check process. Since it was implemented January of last year, 26 complaints were flagged as not having the account holder being aligned with the SFE customer. Do you have any proactive process in place generally, just beyond the name of the account holder, to catch additional problems after the customer is enrolled? I recognize you have, I think, as Mr. Green stated, a 3 or 4 step process at the front door. But once the customer is enrolled a week or two later, is there any proactive sampling by compliance?
So let me clarify, because I think you might have misspoke. Those aren't 26 complaints. Those are 26 instances that my team identified that the account holder record didn't match the signature on the contract.
Correct,
Okay.
yes.
So not complaints. There has only been one incident since implementation of a contract getting processed that it wasn't the account holder of record. It ended up being the husband. It was simply a human error, Your Honor. If you think about it from the perspective of there's a human being reviewing the EDI transactions and clicking yes or no to let it proceed, and it was simply an error in clicking the wrong button that allowed that contract to proceed. But from a perspective of checking afterwards, past that point before allowing the enrollment, we haven't implemented that because we feel that the current checks are correct. If the EDI transaction tells us that's the customer of record, that's the customer of record. That's what we have to rely upon. If it changes post-enrollment, I don't believe that's a violation of any sort under COMAR.
Is it your opinion that SFE was legally obligated to adopt the conditions in the statewise?
No.
With respect to Mr. Auslander's line of questioning regarding the peddler's license and your response that the vendor, iMarket Global, is responsible for securing those licenses, let's say in the city of Baltimore, is this something that you check up on the vendor? You noted that the agreement is supposed to control and have authority over adherence to laws and regulations, but does SFE look behind the agreement to ensure that the agent, the vendor in this case, is actually complying with law?
Our general practice would be to make that check if we actually had a string of complaints in relation to that issue, but from my experience, we haven't received those type of complaints, so those checks haven't been made.
Are you familiar with the Commission's, what's known as an informal vernacular, as the Commission's supplier report card.
Are you referring to what's on the website with the complaint stats, Your Honor?
Correct.
Okay,
3 or
yeah.
more in a
Yes.
month.
Yes, I am familiar with that process, Your Honor.
Are you familiar with that since the Commission has publicly reported effective July 1st, 2019, SFE has, if not has been the leader in terms of complaints, but has been in the top 1, 2, or 3 consistently over the past several years throughout the course of this complaint period?
I'm aware of the stats, Your Honor. Yes, I am.
And would you like to explain, is it just a function of the size of your company, or are there other issues that have been addressed, need to be addressed?
I think it's a combination of all of those elements, and I'll explain further. So, yeah, it's definitely a function of the size of the company, the amount of individuals we're making contact with, the amount of individuals we're entering into contracts with on a residential door-to-door side of things. And it's unfortunate. It's also a product of the commodity landscape as well. I'm sure everybody can appreciate what's happened in the last year or so with commodity rates, utility tariff applications, rates going 30, 40, 50% above what they were, say, 6 months prior. And we had a big uptick in last year between probably about June till September. And what we noticed, the result, we actually did an analysis, and we actually requested a meeting with staff, and that was part of our submissions as part with the disclosure, including our executive report that we provided to staff with our analysis. And what we found with the uptick in complaints during that time period, it was primarily related to customers that had already completed their entire term of their agreement, were issued their required renewal notices, advising them that they'd be going to a month-to-month variable, advising them to contact us if they didn't want that to happen. These customers did not contact us. They were receiving very favorable variable rates up until there was an uptick in commodity prices in the past year, and that uptick resulted in a string of complaints coming to the Commission. But back to your point earlier, out of those complaints, I'm not aware of any of those customers contacting us first, or CAD telling them, asking them whether they contacted us first to resolve their issue.
Thank you. I'll turn to my colleagues, Commissioner Richard.
I really thank you, Mr. Chairman. I'm not going to take a lot of time. I know we have a time limit, but I just wanted to follow up on a couple things. Let me start with the contact us. It seems like one of the themes I read in the filings is your customers have a hard time contacting you. Can you tell me a little bit about your customer service, your call center, or how that happens? Because those who are trying to exercise right of rescission made a comment that they couldn't. Even those who were aware of it, they couldn't. And you just said, contact us, and it seems to be a problem. Can you help me with that?
Sure. In my opinion, there's not a problem. The issue is that the expectation of consumers on response times, on wait times, when calling a call center. I don't know if you've ever experienced it before, but I have. You call your telecommunications company, and I'll be lucky if I can get to a conclusion on my matter within 2 or 3 hours. And 9 times out of 10, I'm on hold for 45 minutes, and they actually push me to an option to text message or get a call back. Our response times for our call wait times, on average, are 7 to 9 minutes, and customers are dropping off because they're frustrated of waiting that amount of period of time. If the Commission feels it's something they want us to increase, we'll go ahead and hire more people and try to reduce the wait times.
Okay, I just looking at complaints, and that seems to be one of the issues that.
And then we do, when we get those complaints, specifically when we see those complaints where the customers are making that specific point, waiting too long, I can't point to specific examples. I'm just going off of memory, but I know that we've had specific cases where customers have said they waited 40 minutes, and we pull the call record, and they waited 9 minutes. Mm-hmm. Right?
Okay.
So.
And just, I think it's been pretty well asked and maybe answered. Sufficient as far as you're concerned, but again, it's the training. It seems like you put a lot of your business model on your door-to-door sales force, yet I was having a hard time really finding out what ownership you have with your contract with your vendor, and also with those individuals. You've described them as, not very sophisticated, not very educated, yet you have a pretty complex product that you expect them to sell in a state that has a lot of customer protections. Can you help me just reconcile what seems to be not a very, I don't know, robust relationship that you really truly have with your sales force?
I appreciate the question, Your Honor. I think the misconception is that, in all fairness, the time period under review and even prior to that, we're talking about COVID, right? We're talking about a situation where even if I wanted to have a staff physically attend, I can't, right? Because I'm putting them at risk. I got to deal with the various state laws and requirements during that whole period of time. We've done better and more frequent visits in the past. And we're in the middle of ramping that up. We've already made changes requiring a minimum of one office visit a month with the vendor. And this is just not in Maryland. As a minimum requirement, regardless of what is going on, and regardless if we identified any potential issues or trends. So we've recognized that we need to increase that as far as the overall monitoring on an ongoing basis after the training's already been conducted and the testing's already been completed, and we've already made that adjustment and we're doing that.
Okay, well, thank you. That does seem to be where a lot of the problems are occurring, right there at the door. So, thank you, Mr. Chairman.
Thank you, Commissioner Linton.
Thank you, Mr. Chairman. Good afternoon. Mr. Donnelly, I will ask only a couple questions, trying to keep us on schedule. First, with regard to the exhibits that SFE has provided, I'm specifically looking at exhibit number 3, which is this chart. But you also have, there's similar data in SFE 11, which was the more horizontal ones, just the top part. And exhibit 6 as well, which is similar. Wait a second. 6 was this one. 6 was like this one. Just wanted to make sure that for all 3 of these, we're talking about Maryland-based data. So there's not any national numbers or regional numbers or anything of that sort.
No, you're correct. This is Maryland-based data only.
Okay. All right. So the chairman did ask one question regarding some complaints that come to the company first before coming to the commission. So for SFE 11, which again is this one, it lists the drops that the company's received since 2019. Are consumer complaints also included in this?
Yes, there'll be a subset of customer complaints. So it'll include customers that called in just to strictly cancel, I don't want it anymore, and there may be customers that called in to cancel and made an indication of a complaint, and then we were able to resolve it with them on that call.
Okay. So I asked this question of the staff witness earlier this morning. What is your understanding of the current posture of the complaints that are the subject of this case? Have those customers, have they all been settled? Are those customers already been refunded? What are we talking about?
Yes. So my full understanding is any of the customers that had a CAD decision in their favor, they were re-rated and cancellation fees waived, obviously. All complaints, we waive cancellation fees, and there's going to be a subset of complaints that were even in our favor where we still re-rated the customer because the customer was maybe being a little bit adamant. CAD maybe asked us to do them a favor, and we obliged.
Okay. Are any of them on appeal either within CAD or to the commission or elsewhere?
Specifically the complaints,
The complaints
during the type?
of this proceeding, yes.
I don't know. On the answer of under appeal elsewhere, no. Under appeal for the time period, I don't have that answer. There might be a few because there's been a lag over the last couple of years of actually getting decisions from CAD. There's, in my opinion, there's a material amount that we haven't got closing letters on. So it's tough to make a determination on what direction we need to take as an organization to better improve things. When we have a response time of X days and we provide all the materials and details and then we sit for, and I know for sure that we've had at least one that we've waited over 6 months to get a CAD decision on, it makes it difficult for us to ensure that we're giving the right consumer protection that CAD wants to see and what the commission wants to see. It makes it difficult for us. In fact, after the show cause was filed, we all of a sudden got a rash of CAD decisions for complaints that were all for the time period that we were sitting waiting for decisions on, and now some of those we're in the middle of appealing.
Okay, so just to be clear then, some of those ones that you might have, as you testified, might have recently received a response to, they're on appeal within CAD.
Correct.
But from the consumer's perspective, they've been re-rated. The financial issues have been resolved. They've been returned to SOS, et cetera.
My understanding in all material cases, that's correct.
Okay. So if you've resolved everything, and I may just pose this more of a comment as opposed to a question. It just depends on how it comes out. But so you have this matter pending here before the commission, but you have some of these same cases that are the subject of this petition still under appeal in CAD.
Yes, I can't recall the actual number, but I do understand that there are some, and it comes down to the same issue with the decision on whether the contract formation is correct or not. So after we made all the changes in the contracts, with the last change being the page numbering in April of last year, we finally started to see CAD decisions that agreed with the contract formation. But then we still are getting some that don't agree. So it's perplexing and difficult for us to move forward when we have that contradictive decision making happening on the contract formation. So the purpose for the appeal is just to bring it to the attention. And I understand that there's staff that, may be new, may be learning. I understand the ins and outs of dealing with compliance and complaints and the amount of consumer complaints you're dealing with. I've been there, done that when I've worked in management positions with regulators. So yeah, people make mistakes, but we need to make sure that we point it out in order so we can move forward on a consistent basis and we're all on the same page.
Okay. All right. With regard to, you testified earlier today that the vendor you're using is a company called iMarket Global. During the period of time in which these cases were presented to the commission, are you still using them, or are they no longer?
No, we're still using them.
You still use
yes, because
okay. Is it your understanding that this is a company that's licensed with the commission, or is that part of your review?
No, this isn't a company that's licensed with the commission.
Okay. All right. So this is a company that is engaged in the business, but it's not a company that's licensed here as a broker.
No.
Or even as a supplier, or just licensed at all.
Yeah, my understanding is that because this is residential sales, and the ultimate responsibility is with us as the supplier, as the licensee, and the broker regime is, my understanding, is meant for commercial interactions in business.
Okay.
But they're exclusive, so we're responsible for them.
Okay. That is the answer I'm hoping to hear.
Yes.
So thank you. Wanted to. There's more to unpack there, but it's always tough to be a commissioner sometimes, on some of these things. But I will. So some things I know I shouldn't ask, even though I might want to. But let me look at very briefly this is SFE 5, the I-sign document. I was specifically looking at page 7, and some of the steps that are taken before that. But I just wanted to make sure I understood when these steps are happening. Are the agents does your training direct the agents to remain at the property while the customer is making the decision up to the touchless consent portion, or have they already left?
No, they're there, Your Honor. It's no different. If you look at it, no different than a paper process. The agent's not going to leave when they're explaining the paper process to the customer, right? Now, they are required to be gone from the premise when the ETPV occurs, and there's a question specifically on that asks the customer.
Okay. So up until the point and I'm still on page 7, where the customer is making the decision about touchless consent, either send SMS or send email. The representative, or the sales representative, is still at the property.
That's correct.
Okay. All right. All right. Yeah, that's, I'll leave us with 4 minutes, Mr. Chairman. Thank you. That's all I'll ask.
Thank you.
Redirect for this witness based on commissioner questioning.
I just have one question.
Yeah, which commissioner?
Based on the training questions that you were asking, Chairman. And Commissioner Boubart. If you look at Staff Exhibit 3C, I believe in reply to reply D, 2-4D, it references a training that took place on February 9th, 2021. Can you verify that that was held over Zoom?
I don't recall at this time.
Can you review the exhibit, please?
Seven, you said? Which exhibit?
Exhibit 3C. It is the data response 2-4. So, and then you look at D, the reply on the back of the sheet.
Uh, 3D, which one? 1, 2, or 3?
The training that took place on February 9th, 2021.
I don't see that. February 8th?
Excuse me?
February 8th?
Oh, I'm sorry, February 8th, 2021.
So D2.
It says that it was conducted by Zoom.
So, you can confirm that SFE has the ability to conduct trainings virtually, correct?
Yes.
Okay, thank you.
Thank you.
All right. Thank you, Mr. Donnelly. You may step down, please. Don't.
Thank you.
Your Honor, I don't have any redirect.
Oh.
I did want to move OPC Exhibit 1C into the record. I don't think I ever did that.
Any objection to 1C? You did not. 1C is moved into evidence. The witness may step down.
Hold on. One question.
Oh, I looked. Nobody had hands up. Yes.
This is in response to the training questions from Commissioner Boubart and you, Mr. Chairman. Mr. Donnelly, is the description of the products that SFE sells part of the training that an agent receives?
Yes, it is.
And so that's on the test?
Yes.
Okay. All right. No more questions. Thank you.
Thank you. Seeing no more questions, the witness is excused.
Thank you, Your Honor.
Closing arguments. If you please keep them brief. The commissioners plan to deliberate quickly and return to the bench so we could get out of here by 5 p.m. this afternoon. I know people have obligations. Mr. Davis.
Okay. Despite a substantial number of complaints, SFE has not demonstrated sufficient evidence that demonstrates that its license should not be revoked, or in the alternative, why the company's business operations in Maryland should not be limited, and a civil penalty should be levied. Staff has shown, and the company acknowledges, the extent of complaints filed against SFE and resolved in favor of customers, as well as the number of complaints filed against SFE in general. For this reason, staff believes that there is sufficient evidence to support the levy of a civil penalty at the very least. Staff's complaint details 136 complaints from CAD, with 46 found in favor of the customer, and this has demonstrated and this was demonstrated through the hearing and the filed testimony. This number of complaints is unacceptable to staff, and our position remains the same, that that substantial action should be taken to make sure that this type of business operation doesn't happen in Maryland and jeopardize consumers.
Thank you. Mr. Auslander.
Thank you, Mr. Chairman. OPC agrees with staff's arguments and their recommendation that sanctions be levied. We would reiterate what we said in our opening remarks, that the Commission should seriously consider a mechanism for ascertaining and awarding customer refunds. During the presentations this afternoon, it was shown that at various points, SFE's door-to-door sales documentation did not contain the short form rescission notice near the signature. That is one basis upon which the commission could explore ordering refunds for all customers that were enrolled on those forms, or at least giving all of those customers an opportunity to rescind the contract as required by the Maryland Door-to-Door Sales Act. So in closing, we do think that the company is failing to adequately monitor their door-to-door sales agents, and I think today's presentation has also shown that there was some problems with the documentation that the company was using at various points. Their defense that they changed those documents moving forward, or implemented some aspects of the settlement reached with Statewise are unavailing, because all they did was bring their action into compliance with the law moving forward, but didn't do anything to retroactively fix any of the harm that they had caused to customers. So we would ask that with whatever else that the commission does today, that they seriously consider a mechanism for exploring customer refunds in this case. Thank you.
Thank you. Mr. Green.
Your Honor, I would reiterate our request that this case be dismissed. As we said in our comments on Monday, though, alternatively, if you're not going to dismiss it, we'd ask for it to be delegated to a hearing examiner, a public utility law judge, and we explored that, some of the procedural ramifications of that in our comments. Staff's case didn't start out well and didn't get any better, and in fact got worse as the case proceeded. They are relying for misrepresentations on a pattern where they say that 15 complaints in the customer's favor out of 46 is a pattern, when there are 29,000 residential Maryland customers, and there are, based on the testimony, well over 1 million customer interactions to result in those sales. In fact, there were 49,000 enrollments during the time period. That is 15 complaints out of 49,000 enrollments. That is not a pattern. In fact, if anything, the 26 complaints that ruled in the company's favor, if 15 is a pattern, then 26 is definitely a pattern. 26 would say that there is no pattern of misrepresentation, or conversely, that there's a pattern of no misrepresentation. And those 26 had specifically recognized that there was no support for the misrepresentation given the documents that were signed in the ETPV. So think about that. The fact that the documents, the contract has the representations in it, the fact that the ETPV has, where the customer has to say it, has to vouch for it, and then the quality assurance call on top of that, where the customer, again, we have a recording, a live recording of the customer talking to a human, not an automated call, saying, I agree they're not the utility. I agree that as of 21, the date when the question about they're not the Maryland Public Service Commission, they're not the government. There are all these safeguards built into the process every step of the way, and there's a reason for that. SFE could have just said, sign this piece of paper, and had all the contract details on there and walked away and signed the person up. And they don't do that because they want this process to work, and they want to make it difficult. And based on the evidence, based on the charts, not all, more than 15,000 customers couldn't make it through the process and were rejected. So if 49,000 got in to the program, right, and another 15,000 were rejected, think about, I can't do lawyer math at all, much less in my head, but whatever percentage of 15,000 of roughly 65,000 customers, I mean, that's a large percentage that are rejected. So I'm not even sure it's 65, actually. But whatever the 15,000 percentage is, it's a big percentage of customers that the company could have taken because they signed the contract. But instead, they couldn't get through the ETPV or the TPV. They couldn't get through the quality assurance, and on the back end, it was discovered that they weren't the account holder. So that's the fact that these allegations swirling about how the company doesn't care or Statewise is shifting operations, none of that is supported today. None of it. So if ever there was a case that should be dismissed, and I understand the rhetoric, and I understand the tension about retail right now, believe me, but this is the wrong case to go forward on with the sanctions that staff has proposed. The unauthorized, we don't see, to the extent there even was a pattern of unauthorized enrollments, that had to do with enrollment of the non-account holder. And if you look at some of these CAD complaints in those instances, I mean, you've got spouses enrolling, a daughter or a son. There are some instances which, there's a landlord. I mean, there's some of the fact patterns don't look good, but I would submit those are isolated incidents. Whenever you see a fact pattern that looks like remarkably weird in a CAD case, chances are it's an isolated incident. So, but be that as it may, this is an issue that the company has, every time a customer wants to enroll, they have to verify more than one occasion throughout the process. I am the account holder. We have it on tape. It's recorded that they're saying I am the account holder. And now you have the back-end check that's been implemented. So, and then finally on the contracts issue, this is an issue that I personally have found perplexing for years now, since it first started to rear its head. But it didn't rear its head for SFE until we got into 2022. So, and SFE was already taking steps to address it because it knew about it in the Statewise case, right? So they made some changes. CAD still ruled against them. They made some changes, and finally we think now they've got it right based on the two decisions that Mr. Donnelly spoke about. One was residential, one was commercial. They are getting some complaints. I don't know if this will get any more, but they were getting some complaints where I think it was April 6, 2022, when the last thing was that CAD wanted was implemented. That was putting the page numbers. So to say there's a pattern when from all of 2020, all of 2021, CAD never raised this issue. No customer ever complained I got inadequate information or my contract format is all messed up. No customer said that. So CAD raised this issue on its own and didn't do it with SFE until 2022. And SFE by then had already started taking the steps, like I said, because they knew about it from Statewise. So there's no pattern there. If anything, it should have been handled a different way for the entire market, because again, this is not, the contract issue is not an SFE or Statewise issue. It is a market issue. Every supplier is dealing with this. In fact, this very issue is on appeal in 2 circuit court cases as we speak with 2 different suppliers. So, and then there's an MTSA allegation. Like I said earlier, those are MTSA cases that involve commercial customers, and frankly, it's a misapplication of the MTSA by CAD. There are CAD decisions that say, that seem to have corrected that recently, that say, in this case, that have been entered into evidence in this record, that say the MTSA does not apply to commercial enrollments. And then finally, on the notice of cancellation, there is a subset of customers that didn't have that notice, but what they did get was a notice of cancellation in virtually every document that they got, right? They were very much aware that they could rescind their contract in 3 days. Like I said, there's a subset, but it's not a pattern. So, and then finally, the argument that was raised about how all SFE did was just shift, or Statewise just shifted all their operations over to SFE, I think that's been soundly refuted. SFE, the testimony is they still have one vendor. They didn't direct that vendor to ramp up. If you look at the customer counts, the enrollment counts, you don't see, if SFE was ramping up, it's not reflected in the enrollments. And that's Exhibit A of where you would see it. The testimony is only reflective of the fact that SFE just continued business operations with the normal speed that they had been doing. So when you add all that up, Your Honor, I would ask that the case be dismissed. I do not believe there's any pattern or practice that suggests there are isolated incidents, and that's unfortunate, but there is no pattern in practice, and I'd ask that this case be dismissed.
We're in recess until 4:55. We are back on the record in case number 9690. The commissioners have had an opportunity to review and give weight to the arguments and the testimony of the parties before us today. Both witnesses, Mr. Herbert and Mr. Donnelly, are credited with the credibility of the testimony that they provided the commission. The commission finds that material issues of fact continue to exist that have not been addressed by today's hearing. Accordingly, the commission will delegate this matter for a trial-type evidentiary hearing before one of the agency's public utility law judges. In the meantime, in order to protect consumers in the state, the commission will establish a moratorium that takes effect at 12:01 a.m. this coming Sunday. The moratorium will prevent SFE from conducting any solicitation door-to-door in the state of Maryland until further notice, until this case is resolved. Additionally, based on some of the admissions and evidence received today, the commission finds that some of the rescission notices were in violation of state regulation in Comar. Any contract that SFE entered into on or before November 26th of 2021 cannot be subject to a cancellation fee. Again, that date is November 26th, 2021. In terms of ground rules for the evidentiary hearing before the judge, OPC noted a number of rules that they would like. We're going to go through each of them one at a time of the 4 rules. OPC requests that we use request for admission of facts pursuant to Rule 36 of the Federal Judicial Rules of Procedure, that we limit the scope of the proceeding. This limiting of the scope of the proceeding was requested by Mr. Green. He also requested that all parties have the ability to issue RAFs for reasons of due process, and the commission concurs. The limit and number of data requests will be limited to 25. To the extent the parties need to issue more than 25, they come back to the judge to request an exemption there. So just to be clear, all parties are permitted, not just staff and OPC, to serve requests for admission. So you may do so.
And Your Honor, you said we're limited to 25 requests for admission?
25. Do you see that as a problem, Mr. Auslander?
Not at the moment. And I think that you said we would have leave to request more if we felt necessary.
Yes. Yeah. It's important, at least at this stage, not to have an unlimited cap. We do want the parties to work together on an expedited basis to move this proceeding forward. In terms of expert witnesses, Mr. Auslander, I know Mr. Green opposes that. To the extent that SFE wishes to use an expert witness, they can petition the Paul J. The Paul J will make that determination. Customers who may wish to testify virtually, yes, we recognize that consumers have busy lives and that coming into the commission to participate in effectively a trial may be inconvenient for some. So for those complainants who filed a complaint with CAD, they may be permitted by the judge to testify virtually in any proceeding. And lastly, OPC requests that SFE produce all of the sales agents in dispute, sales agents that may have misrepresented terms as alleged by either staff or OPC. The commission is not going to direct those sales agents to appear. However, OPC could seek subpoena authority through the commission to compel their attendance. We do recognize that these sales agents, notwithstanding the fact that SFE exhibit number 4 states that they're part of the SFE family. They're also, they don't work for SFE, they work for this iMarket Global vendor, and it would be hard to compel iMarket Global's employees to, from this bench today, to testify. But you may seek subpoena authority from the commission to do so, and we would ask SFE for their cooperation in trying to find these individuals. As the SFE witness noted, they may be hard to track down, they may have left the company weeks, months, years ago, so that will be a challenge. But if SFE does not have a witness, an iMarket Global employee, to rebut the allegations of a customer or of a complainant in this case, that would appear to favor the position of staff and OPC in this matter if you fail to produce a live witness who could rebut the testimony, the live testimony of a customer or former customer. And the judge will make the determinations, and this may end up back at the commission at some point. But I ask the parties to work quickly. Obviously, SFE has an incentive to work quickly with the moratorium in place. And I appreciate the arguments and lawyering of counsel at the table today. Any questions before we adjourn?
Go for it.
Okay, I had a question about what type of timeline the commission is envisioning. I know that you have talked about there being an incentive for the company to work as quickly as possible, but as far as the delegation to the PLJ, would there be, along with that delegation, any kind of indication as to when the commission would like a...
We're not going to impose a deadline on the PLJ's activities. That'll be left up to the judge. The judges are aware that we are currently in the maximum enforcement period. These cases, I don't expect them to run as we've seen in the past 2, 3, or 4 years.
Okay.
These need to, I would expect that this case be wrapped up sometime by late summer, early fall, which sounds like a long time, but in these cases, that's warp speed.
Right.
Mr. Green.
I have a couple of items for clarification. The moratorium, that is on residential door-to-door. The
Correct.
company can continue other marketing channels, especially commercial.
That is correct.
Okay. And then I requested, I believe, that the number of interrogatories also be limited to 25. Were you including that in the 25 limit, or just for requests for admissions?
One moment.
I think given the amount of information that's already come out, the need for truly extensive discovery that can involve hundreds of data requests in these cases is not necessary.
I would, if I may, Your Honor, I think OPC would object to having a limit on the data requests, and one of the reasons that I say that is that, for example, when we sent a question about the peddler's license, we had to send 2 data requests for them to come back finally and say, well, we don't get the peddler's license. We just have an agreement that, that requires the vendor to make sure that the sales agent. So I do think that it might seem like we only need a few questions, but I think when it comes to the data request, we need to have the unlimited amount.
That would count as one. And Mr. Green, why didn't SFE respond to OPC the first time?
I don't know. I can't answer that.
That was prior counsel. Are they prior counsel, or are they still active
They're-
counsel?
They're still active counsel, but I just wasn't involved in the initial discovery rounds. I was not around then.
We'll increase the interrogatories, the data request to 50, subject to leave from the judge for additional DRs.
And then the next question I had, so staff has already filed direct testimony. Is there any, are they, procedurally, do you have any ruling on who files testimony going forward, or whether they can supplement that testimony based on what they've heard today? I don't know that would necessarily be fair, but I wanted to bring that up.
After this hearing ends in a few minutes, this will be within the authority of the assigned judge.
And when there's a limit of 50 data requests, is that each subpart, or
Mr. Auslander, you're not going to get the answers you...
And the reason that I ask is that I think 50 might sound like a lot, but a lot of times when you ask a question, you might ask it with like an A/B, like, tell me how many customers you have in this marketing channel. How
And
many
you
in that-
suspect Mr. Green's going to, if you have 1A through 1C, he's going to view that
I
as
think that
3?
the practice in the commission right now is that parties have, I think in keeping with the fact that we're, trying to do what's in the public interest, we have no limitation whatsoever. So imposing a limitation of 50 is a drastic hampering, in my opinion, of a state agency's ability to do what we need to do as far as taking discovery in this case.
I don't want to bind the hands of the judge. Make any request of additional DRs with the judge.
I think, just for the record, I like to think I'm pretty easy to work with and pretty transparent when it comes to producing responses to discovery. And if staff or if OPC had any issues with an answer, I would encourage them to call or email and going forward and just let me know, and I'll certainly look into whether a supplement is necessary or whether we've properly answered the question.
I fully expect that to be the case, Mr. Green. I expect full communication and cooperation amongst the attorneys at the table today to get this resolved for the benefit of customers.
And we hope Mr. Green remains at the table as opposed to being replaced by somebody else.
Thank you. Mr. Green, just to be clear, since we received various pleadings from various attorneys representing SFE, do you expect to represent them going forward?
Well, my client says yes.
I see you're, okay.
I didn't know I was in danger of being replaced. Apparently I'm not.
Well,
so.
to the extent, because we have other record of counsel in this case, to the extent that they are actively participating, these admonitions apply to them as well.
Right, I understand, and just so you know, I was specifically brought in and told and asked to first chair this case. So the fact that the case still goes, I would assume I would still be in that position.
Well, in less than 2 weeks, you were able to come up to speed. So